you can start, Sukriti. Yeah.
Okay.
A very good morning to all of you. Welcome to the 5th lecture of LiveLaw Practitioner Series. And today we have with us Justice V. Ramkumar, former judge of High Court of Kerala. Very good morning, sir, and thank you for joining us.
Good morning.
So before I switch into sir, I'll just give a brief introduction about Justice V. Ramkumar. So sir did his LLB from Government Law College, Mumbai. He was enrolled as an advocate in the High Court of Kerala on 13th January 1979. During the years 1983 to 1985, he was the secretary of the Rule Committee constituted by the High Court of Kerala under Section 123 of the Code of Civil Procedure. He was directly recruited as the District and Session Judge in the year 1987. From 7 September 2000 to 30 September 2004, he was the Law Secretary to the Government of Kerala under 3 different ministries. He was appointed as a permanent judge in the High Court of Kerala on 7th January 2004. From 14th October 2004 to 7th May 2012, he served as a judge of High Court of Kerala. During his tenure, he pronounced several landmark verdicts. He used to exhibit his artistic flourishes by sketching diagrammatic illustration in some of his judgment, and he was appreciated by the entire legal fraternity. Today, we are highly honored to have sir with us, and sir has been done a lecture previously also, and today, over to you, sir, now. Thank you so much for joining with us.
Thank you, Priyanka. Good morning, friends. Our topic for today is criminal trial on from taking cognizance to framing of charge. See, the curial act of taking cognizance of an offense has baffled the bench and the bar alike, mainly due to the fact that the Code of Criminal Procedure, CRPC for short, has not chosen to define the said expression of taking cognizance of an offense. Although we find the expression used in several sections, such as sections 169, 170, 173, 186, sections 190 to 193, 195 to 198, section 198A, section 198B, sections 199 to 202, then sections 204, 237, 265 capital A, 306, 309, 343, 460, 461, 468, etc. All these sections in the CRPC make mention of taking cognizance of an offense, in spite of the fact that that expression has not been defined under the CRPC. Therefore, it's a complex phenomenon for which an apt definition may not be easy. But at the same time, some type of definition could have been attempted, because it has given rise to various judicial conundrums by various decisions taking different view. We have come across loose expressions such as magistrate applies his mind to the suspected commission of an offense in one case. In another case, magistrate taking notice of the accusations and applying his mind to the allegations. Then magistrate judicially applying his mind to the facts with a view to taking further action. Then again, magistrate becoming aware of the offense, or magistrate taking judicial notice of the offense. Again, the magistrate taking notice of the complaint or the FIR or the information that an offense has been committed. All these expressions have given rise to various shades of meaning without really reaching the correct apt definition of the expression or apt meaning of the expression. The magistrate recording the sworn statement of a complainant and the witnesses. These are all expressions which you find in various decisions of the Apex Court. I am not referring to any High Court, only the Apex Court. A judicial functionary and a legal practitioner cannot remain blissfully ignorant of the curial act of taking cognizance of an offense. When I say curial act, the act of the court, of mainly the magistrate, in taking cognizance of an offense. Very many members of the bench and the bar are still ignorant about the actual curial act of taking cognizance of an offense. Equally important is the curial act of discharging the accused or framing a charge against the accused. There is confusing case law on this aspect as well. In warrant and session trial, all that the court need to consider is whether there is sufficient ground for framing a charge or whether sufficient ground for presuming that the accused has committed an offense. And likewise, for discharging an accused in sessions trial, the only question germane for consideration is whether there is sufficient ground for proceeding against the accused. Whether sufficient ground for proceeding against the accused. You will soon find that these simple expressions in the CRPC have been unnecessarily complicated by various judicial pronouncements. Now, there's these statutory yardsticks have been unnecessarily complicated through some of the judicial pronouncements, which we will soon discuss. Now, before delving deep into the mechanics of the curial process of taking cognizance of an offense, it is relevant to note what are the sources of taking cognizance of an offense. Which are the sources under the CRPC for taking cognizance of an offense? Shall we go to question number 1? Sunita, please.
Sure, sir. Good morning, all.
Good morning.
Reading question number 1. Which are the sources of taking cognizance of an offense?
Yes. Section 190, clause 1 enumerates the 4 sources for taking cognizance of an offense. They are: upon receiving a complaint of facts constituting the offense. Where do you find a complaint? You find the complaint defined under section 2D. Therefore, first source of taking cognizance is a private complaint, loosely called private complaint, which has been defined under section 2D. Then the second source is upon a police report. Police report has been defined under section 2R CRPC. Now, the police, after conducting an investigation under chapter 12 CRPC, they will ultimately file a final report, police report, which can be either to place the accused for trial or not to place the accused for trial. That is the prerogative of the officer in charge of the police station who is conducting the investigation. The investigating officer's prerogative is to arrive at the final conclusion whether to place the accused on trial or not. So police report is another source of taking cognizance for a court. Third source is upon information from a non-police officer. We have seen information from a police officer is police report. Private complaint from a complainant. Then information from a non-police officer. Supposing an accused has been arrested and he is produced before the magistrate. The magistrate may ask him, have you got any complaint against the police? Because there have been cases where police used to torture the accused. They used to manhandle the accused. They used to deploy third-degree methods on the accused. Therefore, the accused has to ascertain from the accused that whether he has been subjected to any manhandling by the police. So when the magistrate ascertains from the accused whether he has been manhandled by the police, supposing the accused says, yes, I was beaten black and blue by this officer, not this officer, the officer who has sent me to the court, to this court. That is a complaint from a non-police officer, information from a non-police officer. Likewise, the magistrate may get information from the internet, newspaper, etc. These are all information from a non-police officer. Last category is upon the own knowledge of the magistrate. When the magistrate is walking along the road, maybe going to court, on the way an offense is committed right in his presence. Mind you, magistrate is the only functionary in the whole gamut of criminal trial who can take cognizance of an offense when committed in his presence, very presence. This is the fourth category. Category 3 and 4 have been clubbed under C. If you go by section 190 CRPC, you will find only A, B, and C. C has been further divided into clause 1 and clause 2. Clause 1 is information from a non-police officer. Clause 2 is when the offense has been committed from the in the very presence of the magistrate. Now, even though there are 4 sources, in actual practice, we have only 2 sources, namely private complaint and police reports. Now we will go to question number 2, Sunita.
Okay, sir. Question number 2. What is the distinction between cognizable and non-cognizable offenses?
See, there is a confusion among not only among the public, members of the public, even among the members of the bench and the bar, though not all, about the distinction between cognizable offense and the curial act of taking cognizance. Even I have come across decisions of the apex court without knowing this distinction. Curial act of taking cognizance of an offense. See, cognizable offense has been defined under section 2C as follows. Cognizable offense means an offense for which, and cognizable case means a case in which a police officer may, in accordance with the first schedule under the CRPC or under any other law for the time being in force, arrest without a warrant. So cognizable offense is an offense for which a police officer is entitled to arrest the offender without a warrant from a magistrate or from a court. In contradistinction, you have the non-cognizable offense, which has been defined under section 2L of CRPC. Non-cognizable offense means an offense for which a non-cognizable case means a case in which a police officer has no authority to arrest the offender, now without a warrant. Now, while in the case of a cognizable offense, the police officer has got the authority to arrest the offender even without a warrant. In the case of a non-cognizable offense, police officer does not have any power to arrest him without the warrant of a magistrate. This is the main distinction between cognizable and non-cognizable offense. While cognizable offenses are graver offenses, non-cognizable offenses are not so grave. And this justifies the fact that the police officer is not enabled to arrest the offender without a warrant from a magistrate. Not only that, and how will you find out whether an offense is cognizable or not? You refer to first schedule of CRPC, wherein part 1 enumerates all the offenses under the Indian Penal Code. Part 2 enumerates the offenses or classifications under other laws apart from IPC. So with regard to Indian Penal Code or other laws, the column 4 of the first schedule, of the table given in the first schedule shows whether the offense is cognizable or non-cognizable. So to find out whether an offense under the IPC or any other law is cognizable or non-cognizable, you will have to refer to column 4 of the tabular statement given in first schedule of CRPC. It will show against the offense is described, offense under the IPC is described. It will show against the offense whether it is cognizable or non-cognizable. If it is a cognizable offense, police officer has got the authority to arrest the offender without a warrant. If it is a non-cognizable offense, police officer does not have any authority to arrest him without a warrant from a magistrate. Now we will discuss the distinction between police report and private complaint, because police report and private complaint, these are the two main sources on which a court of law can take cognizance of the offense. Police report and private complaint. Now, police report, you may read question 3. Sunita.
Sir, question number 3 is, what is a police report and when does it become a source for taking cognizance of an offense?
See, when a complaint is lodged before the officer in charge of a police station, who is also called the station house officer, SHO. When a complaint is lodged before the station house officer, and if the complaint alleges the commission of cognizable offenses, where the police officer has got the authority to arrest without a warrant, the police officer, the station house officer, the officer in charge of the police station is bound to register a crime. He has no other alternative, because the offense alleged is cognizable offense. Now, when a complaint is lodged before the officer in charge of a police station, don't mistake that complaint to a complaint defined under section 2D. 2D defines a complaint which has to be given before a magistrate. That is private complaint. Whereas this is a complaint. This complaint is not necessarily, need not be a complaint as defined. It can be even any information. Section 154 CRPC says, if the officer in charge of a police station receives any information, it can be in the form of a complaint, it can be oral, it can be through telephone, through internet, if he receives any information regarding the commission of a cognizable offense, he has no option except to register a crime. And if he is satisfied that an offense, if he has reason to believe that a cognizable offense has been committed, he has to enter upon investigation. This is the provision under section 154, right in section 157. Therefore, he has no other alternative. That has been settled by the Constitution bench in Lalita Kumari versus State of UP. That is no more res in negra. Of the earlier decisions have been considered, and it has been held beyond any scintilla of doubt that he has no alternative except to register a crime and commence investigation. Now, and after investigation, if he is of the conclusion, if he reaches the conclusion after examining the witnesses, after seizing relevant documents, etc., that an offense, a cognizable offense as alleged has been made out, then he will place the accused for trial before the appropriate court, for which he will have to, if he has arrested the accused, within 24 hours he has to produce the accused before the nearest magistrate. That is a requirement of Article 22(1), 22(2) of the Constitution, as well as Section 57 of the CRPC. Now, but if it is a non-cognizable offense, the police officer cannot register a crime or commence investigation, because Section 155(2) says if it is a non-cognizable offense, the complainant will have to be referred to the magistrate, because without the order of the magistrate, police officer cannot register a crime or commence investigation. Therefore, the police officer can refer the complainant to a magistrate for getting an order under Section 155(2) CRPC. And very often, police officers themselves will approach the magistrate for orders. When we are in a complainant-friendly state, nothing wrong in the police officer himself, the station house officer himself approaching the magistrate and getting orders, instead of directing the complainant to move the magistrate. That practice has been recognized by the Supreme Court in a decision which I had occasion to refer to in the earlier lecture. Now, question 4. What is a private complaint? You may.
Question number 4. What is a private complaint and whether it can include both cognizable and non-cognizable offenses?
Yes. Section 2D of CRPC defines what is a private complaint. 2D says complaint means any allegation made orally or in writing to a magistrate, mind you, not to a police officer, to a magistrate, with a view to his taking action under this code, that some person, whether known or unknown, has committed an offense but does not include a police report. So if it is the private complaint cannot include a police report. Police report has its own channel, its own channel of reaching the magistrate. But a private complaint has its own separate channel. Private complaint can be directly filed before the magistrate. A complainant in a private complaint can even short circuit the magistrate, the police. He need not necessarily move the police for filing a complaint before the magistrate. And in such a case, barring 1 or 2 exceptions, the magistrate can, during 202 inquiry, refer the order investigation, direct investigation by the police or any other person. Therefore, it is not the requirement of law that before moving a magistrate, the complainant should move the police. But if there can be situations where a complainant may not be interested in moving the police, because supposing the offender himself is the police, the respondent, the accused himself is the police, or the respondent is a police officer of some other station and having direct nexus with the local police where the offense has been committed. In those cases, he exercises in futility if he files a lodged a complaint before the police. Therefore, he will be justified in directly approaching the magistrate. Now, the expression of an offense under section 2D can include not only cognizable offense but also non-cognizable offense. Now we go to the distinction between the curial act of taking cognizance and and cognizable offense. Question 5.
So that exactly is question number 5. What is the distinction between cognizable offense and the curial act of taking cognizance of an offense?
See, we have seen what is a cognizable offense. Cognizable offense is the offense in which the police officer is entitled to arrest the offender without a warrant from a magistrate. That is cognizable offense. Whereas the curial act of taking cognizance is an act of the court, magistrate, for taking cognizance. See, under the if it is an offense under the Indian Penal Code, then you have to see whether it is a cognizable offense or non-cognizable offense. If it is a cognizable offense or non-cognizable, if it is a cognizable offense, police officer can arrest an offender, and in the absence of any other criteria for the offense, police officer can also register an FIR, conduct investigation, and finally charge sheet the accused if he is guilty, or file a refer report if he is not guilty. Now, in the case of private complaint, the act of taking cognizance of an offense, the curial act of taking cognizance of offense, can be both on a police report as well as private complaint. We have seen section 90, 4 sources of taking cognizance. One source is private complaint. Second source is police report. Now, here is a question whether taking cognizance has anything to do with the curial act of taking cognizance of an offense. When the magistrate receives a police report or a private complaint alleging offences, whether cognizable or non-cognizable, then if it is an IPC offence under the IPC, when in the absence of any special circumstances falling under chapter 14, section 190, chapter 15. I'm sorry, chapter 14. The magistrate can take cognizance of the offence. Now, taking cognizance of the offence can be on a police report or on a private complaint, except otherwise barred by the CRP or any other law. Now, there is a popular misconception that a magistrate can take cognizance on a private complaint only in respect of a cognizable offence, because the word non-cognizable offence seems to give some confusion. There are some members of the bar as well as bench holding the view that if it is a non-cognizable offence, the magistrate cannot take cognizance of an offence. Not correct. See, whether the offence is cognizable or non-cognizable, the first stage of a criminal case before a criminal court is the stage of initiation of proceedings. Initiation of proceedings starting from section 200 onwards in chapter 15 CRPC. Therefore, initiation of proceeding means if it is a police report, the magistrate can take cognizance straight away. If he is satisfied from the charge sheet as well as the documents produced along with the charge sheet that the offence alleged has been made out. If it is a private complaint, the magistrate will have to peruse the private complaint and the materials produced along with the private complaint. And if he is satisfied that an offence has been made, whether cognizable or non-cognizable, he has to take cognizance of the offence, which is the first stage in the initiation of proceedings. See, once the initiation is over, then only he can proceed to the next stage, namely commencement of proceedings. That is in chapter 16. Now, we pass on to question 7, which will make the position clear.
So are we skipping question number 6?
6, what is that? 6. Yes.
Okay.
One second. I think I missed that. Question 6, yes.
Yes. Question number 6. After registering an FIR for a cognizable offence, the police arrests the accused and produces him before the magistrate without a remand report. With a remand report, the magistrate applies his mind to the FIR and remand report and remands the accused to judicial custody for 14 days. Has the magistrate taken cognizance of the offence?
See, you got the facts clearly. The cognizable offence has been committed. Station house officer got information that a cognizable offence has been committed. A complaint was lodged before him. He registered an FIR, and as a step in the course of investigation, he proceeded to the spot, arrested the offender, and he files a remand application before the magistrate, produces the offender before the magistrate, He has to produce him within 24 hours of his arrest. Therefore, he arrested the offender and produced him. He registered an FIR and he produced the offender before the magistrate, nearest magistrate, under section 1, in obedience to section 167(1) CRPC, and along with the FIR and averments and the 167(1) says the extracts of the diary maintained by him. Extracts of the diary maintained by him is the case diary, investigation file diary. He will have to give the magistrate the extract of the diary also while forwarding the accused along with the FIR. The magistrate is the nearest magistrate, mind you. He need not necessarily be the jurisdictional magistrate. Therefore, when the accused is forwarded to the nearest magistrate, he peruses the FIR and the remand application, which will extract the diary, which will be containing the diary extract also. Separately, it is not being sent by police, even though law requires that it has to be separately sent. But very often, what they do, at least in our state, is along with the remand application, they will incorporate the diary extract as to the investigation so far conducted, and then the FIR also. Magistrate, after perusing the FIR and the records, he remands the accused to judicial custody for 14 days or 15 days. Has not the magistrate taken cognizance of the offence? Is the question. What do you say, Sunita? Has not the magistrate taken cognizance of the offence?
I'm not
He
really
has got
sure
the
about
FIR.
that.
He has got the FIR before him. FIR mentions about the cognizable offence committed by him. See, very often there is a misconception that a magistrate is taking cognizance on an FIR. You're wrong, Mr. Bandyopadhyaya. See, I mentioned to you the 4 sources for taking cognizance. They are police report, private complaint, the information from a non-police officer, and offense committed right in the presence of the magistrate. These are the only 4 sources for taking cognizance. What is a police report? Police report is the report filed by the police after the conclusion of investigation. Here, what has been filed is only the FIR. FIR is the earliest document by which the criminal law is only set in motion by lodging a complaint. A cognizable offense has been committed. I have seen the offense being committed. That is what the complainant says. Or somebody told me that an offense has been committed. Therefore, please register a crime for a cognizable offense. That is the first stage before a police for the registration of a cognizable offense. Now, that FIR is not a complete document. FIR, of course, section 157 CRPC mandates that once an FIR is registered, it has to be sent to the magistrate having jurisdiction, nearest magistrate or magistrate having jurisdiction. Therefore, when an FIR is sent to the magistrate and FIR has been registered and has been included in the record of the magistrate court, you cannot say that the case is pending before the magistrate. That FIR, after the conclusion of the FIR, pursuant to the FIR, the police officer will conduct investigation pursuant to the FIR. And it is only after the conclusion of investigation that he will file a final report, that is police report or charge sheet or challan. That challan is called the police report, which is one of the sources for taking cognizance. He is not taking cognizance of the FIR. Therefore, I put this problem only to confuse you, because I knew that you will say that he has taken cognizance. No problem. There are very many. You are in happy company of very many ignorant persons. Therefore, he has not taken cognizance of the offense. He can take cognizance of the offense only after the conclusion of investigation. Police file a charge sheet, 173(2) under section 173(2) CRPC. Therefore, the court has not taken cognizance. For a decision on this point, State of Karnataka versus Pastor P. Rajan, 2006, 6 SCC 728, 2006, volume 6 SCC 728. You need not take down the citations. I will give you the notes after the lecture. Notes will be circulated through LiveLaw. Now, therefore, When an FIR is filed and the court is remanding the accused after perusing the FIR, court is not taking cognizance of the offense. Court can take cognizance of an offense in a case investigated by the police only after the filing of the charge sheet by the police. Now we pass on to question 7.
Moving on to question number 7. When a cognizable offense is brought to the notice of the magistrate in a police report under section 190 clause 1b CRPC, is the magistrate bound to take cognizance of the offense?
So section 191 CRPC says the magistrate may take cognizance of the offense on any of the four sources. The 4 sources are mentioned under section 190 clause 1 and says the magistrate may. But our Supreme Court has taken the view that if a cognizable offense, commission of a cognizable offense is made out on a police report filed under section 173(2) CRPC, even though the expression used is may, the court is bound to take cognizance. Court has no alternative because the commission of a cognizable offense is brought to the notice of the court. Court has to take cognizance on a police report. That is the A.C. Agarwal, subdivisional magistrate versus Ramkumar, AIR 1968 Supreme Court 1. It is a constitutional bench decision by a constitutional bench. The constitutional bench held that when a charge sheet alleging the commission of a cognizable offense has been filed before the court, court is bound to take cognizance, notwithstanding the fact that section 190 only says may, court shall. Question 8.
Question number 8. Will cognizance taken on an incomplete police report vitiate the proceedings?
Vitiate the proceedings. It should not vitiate the proceedings because just because the final report or the charge sheet filed by the police is incomplete, you cannot say that it is so incomplete that the magistrate or the court cannot take cognizance of it. Therefore, even on an incomplete charge sheet, the magistrate will be well justified in taking cognizance of the offense. Therefore, the incompleteness of the final report filed before the magistrate does not affect the power of the magistrate to take cognizance of the offense. You may refer to Tara Singh versus State AIR 1951 Supreme Court 441. 4 judges. The decision by 4 judges. Question 9.
Question number 9. Can a magistrate who does not have territorial jurisdiction to try the case take cognizance of the offense?
Supposing the offense is committed in Punjab, can a magistrate in Cochin, in Kerala, take cognizance of the offense? That is the question which came up for consideration before the apex court. The court said the magistrate taking cognizance of an offense need not necessarily have the jurisdiction to try the case as well. The provisions of sections 177 to 179 and 179 CRPC, which decide the jurisdiction of the court, do not trammel the powers of the court to take cognizance of the offense. Is the view taken by the Supreme Court in Trison's Chemical Industry versus Rajesh, Volume 8 SCC 686, corresponding to 1999 Criminal Law Journal 4325, Supreme Court. But I have some reservations about this judgment because this verdict does not take into account section 170, section 173(2)(1) and section 204(1) CRPC. If those provisions are read, then what the CRPC says is that the magistrate, the charge sheet shall be filed before the magistrate entitled to take cognizance of the offense and try the offender. Both should be there, going by these provisions. So the magistrate who is the charge sheet shall be filed before that court which is entitled to take cognizance and try. Means the court which can try the offender alone can take cognizance is the indirect meaning. Anyway, so long as that decision holds the field, we are all bound by the rulings in that decision. Then, taking cognizance of an offense on a private complaint. Now, I will give you 6 situations. You may read question number 10.
Yeah. So, shall I read the situations first?
No, question and then the situation.
Okay. So there are two parts to this question. A,
Yes.
has the magistrate taken cognizance of the offence in any of the following 6 situations?
Yes.
B, if the magistrate has taken cognizance of the offences in any of the following situations, in which situation did he first take cognizance of the offences?
Yes. Now see, these are all questions framed by me due to my experience in practical situations, because any law is better understood when you apply the law to the practical situation, concrete fact situation. There's no point in giving a lecture on abstract law. That lecture will be appreciated and you forget about that. But by discussing the law to concrete fact situations, you know the law better and you go home wiser. That is the purpose of these questions which I have formulated. You are only helping me to read the question. That's all. Thank you. 6 situations you may read.
So first one, at 4:30 p.m., a magistrate receives a private complaint alleging the commission of cognizable offences by the named accused therein. The complainant and his witness are present. After going through the complaint, the magistrate looks up at the clock and adjourns the case to the next day.
Now, please stop there. We will discuss each situation separately.
Okay, sir.
Now, here is a case, a private complaint alleging cognizable offences have been filed before the magistrate. It comes up before the magistrate for consideration at 4:30 p.m. in the evening. The complainant is before the magistrate, standing before the magistrate. His witnesses are also in attendance, and the magistrate reads the complaint. Then adjourns he looks up at the clock, 5 o'clock, time for me to rise. Case adjourned. He is adjourning the case to the next day. This is situation number 1. Then situation number 2. You may read.
Situation number 2. In the above situation, instead of adjourning the case, the magistrate issued a search warrant as requested by the complainant.
So, in the complaint filed by the complainant, he has also filed a request, made a request for issuing a search warrant for enabling him to substantiate his allegation. Magistrate issued a search warrant. Then 3.
Situation 3. In the above situation, the magistrate, after making a record in the proceedings which reads, for recording the sworn statement of the complainant and the witnesses, adjourns the case to the next day.
Yes. See, first case was the magistrate went through the entire complaint. Complaint was in front of him. He looked into the papers, etc. Then looked up at the watch. Time for him to rise. So he simply adjourned the complaint to the next day. Second, he issued a search warrant as requested by the complaint. Now, third is, instead of simply adjourning the case, he made a record in the proceeding paper for recording the sworn statement of the complainant and the witnesses. And he asked the complainant to come next day for recording his sworn statement. Sworn statement was not recorded, mind you. He has not recorded the sworn statement. He has only adjourned the case for recording the sworn statement. That is illustrated the situation number 3. Now 4.
Fourth situation. In situation 1, above, the magistrate, after adjourning the case, records the sworn statement of the complainant and the witnesses on the next day.
Yes. Next day, for the first time, he actually records the sworn statement of the complainant and the witnesses. Next day. So that is the 4th situation. Yes.
The 5th situation. After using the complaint, the magistrate applies his mind and forwards the complaint to the police under section 156 clause 3 CRPC for investigation and report.
Yes. That is, complainant filed the complaint. Complaint is perused by the magistrate. Magistrate applies his mind and then forward the complaint, because he had not gone to the police. The complainant had not gone to the police. So he forwarded the complaint to the police under section 156.3 CRPC for investigation. Because the complainant had bypassed the police. So magistrate is not inclined to take cognizance of the offence straight away. Therefore, he forwarded the complaint to the police after applying his mind to the averments in the complaint. Whether the magistrate has taken cognizance of is the question. Then, last situation.
Last situation. After recording the sworn statement of the complainant and the witnesses, the magistrate issues summons to the accused.
Yes. So here he not only recorded the own statement of the complainant and the witnesses, thereafter on being satisfied that the complaint is genuinely has been, there is a genuine affirmation of having committed a cognizable offense, he issued a search warrant, he issued process, he issued summons to the accused. Now in these cases the question is, has the magistrate taken cognizance of in any of these situations? Second issue is, if at all he has taken cognizance in any of these situations, in which case has he taken cognizance for the first time? In the first case, first illustration, the magistrate only simply adjourned the case. After reading the complaint, applying his mind, he only adjourned the case, saying that it is time for me to rise. He has not taken cognizance at all. He cannot be. Second case, what did he do? Second case, he issued a search warrant as requested by the complainant. There also he has not done anything towards the recording of own statement, etc. Third case, there also he did not record the own statement, but only made a statement in the diary proceedings paper for recording the own statement of the complainant. Recording is yet to take place on the next day. So as the magistrate taken cognizance. Now you may kindly note that there is a catena of decisions of the Supreme Court, whereby the Supreme Court has taken the view that if the magistrate, after perusing the averments in the complaint, has decided to proceed under Chapter 15 CRPC on a private complaint, after reading the averments in the complaint, the magistrate has decided to proceed to Chapter 15, starting with Section 200, namely recording of own statement, he can legitimately be said to have taken cognizance of the offense, because he need not actually record his own statement, because he has only taken the decision to proceed under Chapter 15. That is because, of course, there were decisions earlier by the Supreme Court that he takes cognizance only when he actually records his own statement. Another line of decisions, he takes cognizance only when he actually issues process. All those decisions are not correct, because when after perusing the averments in the complaint, the magistrate decides to proceed under Chapter 15, starting with Section 200 onwards, he can legitimately be said to have taken cognizance of it. After the decision in Adalat Prasad, which overruled the decision which went from Kerala, K. Matthew 92 Supreme Court was overruled by Adalat Prasad, and Adalat Prasad versus Ruplal Jindal, I think it is 2003 Supreme Court held that once the magistrate takes a particular step or crosses a particular stage, he cannot retrace his step backwards. So here is a case where the magistrate has already taken a decision to proceed under Chapter 15 by making a record for recording the own statement of the complainant and the witnesses. That means he has decided to proceed under Chapter 15. He has decided to proceed under Section 200 CRPC in Chapter 15. Therefore, he can be said to have taken cognizance of the offense. And if he has issued process thereafter, it is at the post-cognizance stage. Issuance of process is at the post-cognizance stage. It's not the stage of taking cognizance. Likewise, if without proceeding under Chapter 15, if the magistrate issues a search warrant, he is not proceeding under Chapter 15. He is proceeding under Section 91 by issuing a search warrant. Therefore, he is not proceeding under Chapter 15. For that reason, he cannot be said to have taken cognizance of the offense. Likewise, when on receiving the complaint, the magistrate applies his mind and forwards the complaint to the police for investigation under Section 156(3) CRPC, then also he is not proceeding under Chapter 15. He is proceeding under Chapter 12. Therefore, he is proceeding under Chapter 12, and therefore, he cannot be said to have taken cognizance of the offense. Then process, I have said, it is at the post-cognizance stage. Then the first decision of the Supreme Court by a 3-judge bench of the Supreme Court was R.R. Chari versus State of UP, AR 1951-207, 3 judges. In paragraph 9 of the judgment, the learned judges were actually extracting, physically lifting a particular phrase, passage from the judgment of the Calcutta High Court, the judgment of Justice Das Gupta in AR 1950 Calcutta 437. A particular passage of that learned judge was extracted by the Supreme Court, 3 judges bench of Supreme Court, saying that this is the beautiful way of expressing when does the magistrate take cognizance of an offense. When a magistrate, after perusing the averments in the complaint, applies his mind for the purpose of proceeding under Chapter 15, he can be said to have taken cognizance of the offense. And if on the contrary, he is only forwarding the complaint to the police under 153 or issuing a search warrant, etc., you can't say that he has proceeded under Chapter 15. Therefore, he cannot be said to have taken cognizance of the offense. This was followed by Narayan Das Bhagwat Das versus State of West Bengal, AR 1959 Supreme Court 1118. Again, AR 1964 Supreme Court 1541, 3 judges. Again, 1971 Supreme Court, 1971 Volume 3 SCC 936 Constitutional Bench, 5 judges. Again, 1972 AR 1972 Supreme Court 3629, AR 1972 Supreme Court 3629. Again, AR 1976 Supreme Court 1672, AR 1976 Supreme Court 1672, 3 judges. That is Devarapalli, Lakshmi Narayana Reddy and others versus Narayana Reddy. Again, 2008 2 SEC 492, 2008 Volume 2 SEC 492. Again, paragraph 35 of Subramanian Swamy versus Manmohan Singh, 2012 Volume 3 SEC 64. Now, all these decisions Supreme Court said, if the magistrate is on a private complaint, the magistrate has taken, has only forwarded the complaint to the police. He is proceeding under, not under Chapter 15. He is forwarding the complaint to the police for investigation under Chapter 12. Likewise, if he is issuing a search warrant, he is not proceeding under Chapter 15. But once he has applied his mind for the purpose of proceeding under Chapter 15, you can say that magistrate has taken cognizance of the offense. Then, in the case of issuing a search, that process is at the post-cognizance stage. 2005 7 SEC 467. Supreme Court clarified that issuing process is not taking cognizance, but after the cognizance has been taken, it is at the post-cognizance stage. Again, State of Karnataka versus Pastor P. Rajan, 2006 6 SEC 728. This is also at the post-cognizance stage, issuing process. Cognizance has already been taken by proceeding under Chapter 15. Yes, now you may go to, now those who are listening this lecture, please, at least from now onwards, never make any mistake of taking cognizance on a private complaint. When a private complaint is received and the magistrate, after applying his mind to the averment, applies his mind for the purpose of proceeding under Chapter 15, he can be said to have taken cognizance. Of course, the process of cognizance is a complex process. It may go up to the dismissal of the complaint under Section 203 or the issuance of process under Section 204. But the process of taking cognizance has started with the magistrate deciding to proceed under Chapter 15. Because we will soon come across that with regard to certain private complainants, they are exempted from examination under Section 200. But then the magistrate has decided, if the magistrate has decided to proceed under Chapter 15, he can be said to have taken cognizance of it. Hereafter, nobody should make any mistake on that. Yes, question 11.
Question number 11. Is there any category of persons exempted from examination under Section 200 CRPC? And if so, who are they?
There are 3 categories of persons who are exempted from examination under Section 200. First category is a public servant acting or purporting to act in the discharge of his official duties by virtue of Clause A to 1, the first proviso to Section 200. Clause A to first proviso to Section 200 exempts a public servant who is acting or purporting to act as public servant in the discharge of his official duty. if an offense is committed. For example, the other day we discussed section 195(1)(a), which enumerates various offenses starting from section 172 to 188 of the Indian Penal Code. All offenses committed before a public servant. I brought to your notice the latest decision of the Madras High Court saying that no police officer shall register an FIR with regard to those offenses committed before a public servant. Therefore, if been committed before a public servant in the discharge of his official duties, then he alone can file a complaint. And when he files such a complaint, he is exempted under clause A of the first proviso to section 200 CRPC from examination. The public servant need not be examined under section 200. Then second category is a magistrate who makes over a case under for inquiry for trial to another magistrate under section 192. A magistrate who gets a complaint can make over a complaint to another magistrate for inquiry. For example, if we have seen the sources for taking cognizance. Last source, when an offense is committed right in the presence of the magistrate has taken cognizance of the offense, then magistrate is virtually in the shoes of a complainant. He is virtually in the position of a complainant because he has taken cognizance of offense, and if he himself conducts the trial, it may not be a fair trial because he has seen the offense being committed right in his presence. Maybe the offender was exercising his right of private defense. Nobody knows. Magistrate has only seen the offender committing an offense. Therefore, he took cognizance of offense. And it may not be proper for the magistrate to conduct the trial himself. Therefore, there is an option given under the CRPC. He can be given an option to have the trial conducted before the same magistrate or some other magistrate. If he exercises that option, the accused offender exercises the option and says, no, you need not try the offense. You are a biased magistrate. Then magistrate can make over the case to another magistrate. Likewise, if that is done, that magistrate need not record this own statement of the complainant. That is second category of exemption. Third is court. When the court is a complainant, when the complaint has been filed by the court, private complaint has been filed by the court, then court need not be examined. First of all, court itself will not come as the complainant. Court will be the complainant in the complaint, but then a person authorized by the court will produce the complaint before the court. Now we come across the other day offences enumerated under section 195(1)(b) CRPC, where offences have been committed before courts. False evidence, fabricating false evidence, all those offences committed before a court. In such case, if the court is satisfied that he should be prosecuted, a witness who has committed false evidence should be prosecuted, court will be the complainant. Court alone can be the complainant under section 195(1)(b). Therefore, when such a court is the complainant, court is exempted from examination under section 200 CRPC. These are the three categories of persons. That is clause A of the proviso to section 200. Question 12.
Question number 12. When a magistrate making over the complaint to another magistrate under section 192 CRPC has been exempted from examining the complainant and the witnesses by virtue of clause B to the first proviso to section 200 CRPC, does not the proviso to the said clause B contradict the said clause B?
See the under section 200, under 192, see 192, any chief judicial magistrate may, after taking cognizance of, make over the case to the inquiry for trial to the competent magistrate subordinate to him. Any magistrate of first class empowered in this behalf by the chief judicial magistrate may, after taking cognizance of an offence, make over the case for inquiry or trial to such other competent magistrate as the chief judicial magistrate may by general or special order specify, and thereupon such magistrate may hold the inquiry or trial. Therefore, Chief Judicial Magistrate, being having supervisory control over all the judicial magistrates under him, may issue general or special orders authorizing certain magistrates to decide certain category of cases. So when a magistrate receives a complaint, and if according to that magistrate it should be tried by another magistrate having that particular subject matter, etc., which as per the general order of the CJM has been allocated to that magistrate, he can, with the permission of the CJM, transfer that case to the, make over that case to the magistrate having jurisdiction. In such cases, see, under clause B of the first proviso to section 200, see clause, section 200. Provided that when a complaint is made in writing, the magistrate need not examine the complainant and the witnesses if the magistrate makes over the case for inquiry or trial to another magistrate under section 192. To another magistrate under 192. Then the question says, by clause B to first proviso 200, that's not the proviso to say contradict the clause B. See, the clause B says, if the complaint is not in writing, direct the complainant to if the magistrate makes over the case for inquiry or trial to another magistrate under section 192, provide further that the magistrate makes over the case to another magistrate under the, after examining the complainant and the witnesses, the latter magistrate need not re-examine them. What the proviso says is, once the magistrate has made over the complaint to another magistrate, and that magistrate need not record the sworn statement of that magistrate need not be recorded, but need not be recorded. What the section says is, the magistrate need not examine the complainant and the witnesses. Is the first proviso to section 200. Therefore, if in a case the magistrate has forwarded the complaint to another magistrate, the proviso says that magistrate need not re-examine. If the magistrate need not means he should not. It need not be. It cannot be read as should not. The proviso to section 200 cannot be read as should not. A magistrate making over the complaint to another magistrate under section 192 need not record the sworn statement. His sworn statement need not be recorded is the provision. Should not be recorded, it's not the provision. Therefore, if in a given case the sworn statement of the magistrate is recorded, nothing wrong, because there is no total interdict against the recording of the sworn statement of the magistrate. Therefore, in a given case, the sworn statement of a magistrate passing orders under section 192 has been recorded, then the proviso to section says that this magistrate to whom the case has been transferred need not re-record, re-examine the sworn statement of the sworn statement need not be re-examined. So therefore, there is no contradiction between the two provisions. Yes. Question 70.
So 13.
13.
Yeah.
Yes.
Question number 13. Can a complaint which does not make out any offense be dismissed at the threshold?
See, supposing a magistrate receives a complaint on the after reading the entire complaint 2 or 3 times, magistrate is not at all satisfied about the ingredients of the offense. The ingredients of the offense have not been alleged in the complaint. The complaint does not make out any offense. Therefore, if he takes cognizance of the offense, then he will be unnecessarily dragging the accused to the ordeal of a trial. Why should the precious time of the magistrate be wasted? Can he not dismiss the complaint under section 203 CRPC? Can he not? Sunita, what is your opinion? Complaint on the face of it, ex facie, does not make out any offense. No offense is made out at all. Can he not dismiss the complaint under section 203? Otherwise, it will be an exercise in futility. See, if you first blush, you may be inclined to say that he can. But if you read section 203 carefully, see section 203 and read section 203. If after, okay, you can read 203.
Section 203, dismissal of complaint.
Yes.
If after considering the statements on oath of the complainant and of the witnesses and the result of the inquiry or investigation.
If after considering the statement of the complainant and the witnesses, if any, and after considering the inquiry, if any,
Yeah.
conducted under 202, then only the magistrate can dismiss the complaint under 203. But here what we have is a complaint on the face of it. Ex facie does not make out any offense. Therefore, can the magistrate dismiss the complaint under section 203 is the question. He cannot certainly dismiss the complaint under section 203. But at the same time, if he takes cognizance of the offense and crosses over, then it will be an unnecessary empty formality. Why unnecessarily record the sworn statement of the complainant and the witnesses when the complaint on the face of it does not make out an offense? Complaint is not like an FIR. FIR is the stage when the criminal law is set in motion, and FIR will be followed by an investigation, which will ultimately result in a police report. And complaint is yet another source of taking cognizance, like a police report. Police report should be complete regarding the commission of the offense. Likewise, a complaint which is one of the sources for taking cognizance also should be complete. Therefore, if the complaint is not complete, or if the ingredients of the offense are not alleged in the complaint, then the magistrate should not waste his precious time in taking cognizance and examining the complainant and the witnesses. Therefore, even though CRPC does not have any specific provision, the Kerala High Court had taken the view that the complaint can be rejected. The complaint can be rejected at the threshold. A complaint which does not make out any offense at all can be rejected. There is no prohibition in the CRPC. In the absence of a prohibition, complaint can be rejected. It is called rejection. And Kerala High Court has gone further to say that even if the magistrate wrongly says complaint is dismissed, it is not dismissal under 203, but it is rejection at the threshold. In a case where complaint does not make out any offense at all. The citation is Biju Purushothaman versus State of Kerala, 2008, 3 KLT 85, corresponding to 2008 Criminal Law Journal 4488. 4488. We may pass on to question number 14.
Okay, moving on to question number 14. Is inquiry under section 202 CRPC a must in all situations?
See, section 200 is the section enabling a magistrate to take cognizance. Now, he has recorded the sworn statement of the complainant and the witnesses. After recording the sworn statement of the complainant and the witnesses also, magistrate is in two minds. He is not convinced whether the offense is made out or not. But at the same time, he has a hunch that some offense must have been committed. He has a hunch that the offense has been committed, but the statement of the complainant and the witnesses do not make out the offense. What should we do? Then he can cross over to section 202, which is the next stage. He can cross over to 202 and himself conduct an inquiry under section 202 by examining witnesses, or he can forward the complaint to the police for investigation. Not necessarily police, even to a private person, even to an advocate for investigation under section 202 clause 1. So when the magistrate is in doubt, but at the same time he has a hunch or hesitation that there is some offense committed, I am sure about that, but the complainant, the testimony, the oral statement, oral examination of the complainant and the witnesses do not clearly make out the offense. So he will have to conduct an inquiry to find out the offense. All aspects of the offense have come out. Therefore, he can conduct an inquiry. It is only optional. It is only when the magistrate is in doubt he can proceed to 202. But 202 inquiry is a must in two situations. In two situations, 202 inquiry is a must. Number one, if any of the accused is residing outside the local limits of the magistrate's court. If any of the accused is residing outside the territorial limits of the magistrate court, by virtue of an amendment, there is a requirement that 202 inquiry should be conducted. That is one situation where 202 inquiry is a must. Second situation is if the offences are exclusively triable, is clause A to proviso. Clause A to the proviso to section 202 clause 2. If the offence is exclusively triable by a court of session, then inquiry is a must. And rather, the 202 inquiry is a must. It is not optional for the magistrate. He has no discretion. He has to conduct an inquiry. Question 15.
Question number 15. Barring the above situations, is inquiry under section 202 clause 1 CRPC compulsory?
No, I already told you, it is not compulsory except in the two situations already mentioned. And if the magistrate entertains some doubt regarding the commission of the offence after recording the sworn statement of the complainant and witness, if he still is in doubt, he can cross over to 202. But 202 inquiry is a must in two situations where any of the accused is residing outside the territorial limits of the magistrate, or the offence is exclusively triable by a court of session. Yes. Question 16.
Question number 16. Are there situations where the magistrate cannot direct investigation by the police under section 202 clause 1 CRPC in respect of any case? And if so, which are they?
Yes. If the offence is exclusively triable by a court of session by virtue of clause A to the proviso to section 202(1) CRPC, magistrate is debarred from directing investigation. Magistrate cannot, if the offences are exclusively triable by a court of session, by virtue of the clause A to proviso to section 202(1), magistrate is debarred from forwarding the complaint to the police or any person for investigation. Second, similarly, in a case where complaint has been made by a court, the court is the complainant. We already noted that court can be the complainant. Complaint has been given by a court. No direction for investigation can be given in view of clause B to the proviso to section 202(1) CRPC. See, we have considered two situations. When one is 202 inquiry, whether it is a must or not. 202 inquiry is not a must only when the magistrate entertains a doubt, but it is a must if any of the accused is residing outside the magistrate local limits, or the offence is exclusively triable by a court of session. Then second question is whether even where the court has conducting an inquiry under 202, whether the magistrate can forward the complaint for investigation to the police or anybody else. Two cases he cannot. Number one, where the offence is triable exclusively by a court of session, he cannot. Similarly, where the complaint has been preferred by a court, he cannot forward the complaint for investigation by the police. Yes, question 17.
Question number 17. Why is that the proviso to section 202 clause 2 CRPC contains a mandatory inquiry by the magistrate if the offence is triable exclusively by the court of sessions?
See, we have already seen that if the offence alleged in the private complaint filed before the magistrate is exclusively triable by a court of session, he is debarred from forwarding the complaint to the police, is it not? And he has to mandatorily conduct an inquiry. Why? What could be the reason? What could be the reason? Because offences are exclusively triable by a court of session. The case which came up before the magistrate is not a police report. No previous investigation has been conducted by the police. It's a private complaint. Complainant has no power to conduct any investigation. So there is no investigation conducted. And the case ultimately will have to be committed to the court of session for trial. So when the case is committed to the court of session for trial, the witnesses mentioned in the private complaint, the defense will have no advantage. The defense will be at an advantage, at a disadvantage in cross-examining the witnesses for want of a previous statement. Had it been a police investigation, there will be the 161 statement of the police, of the witnesses. When a witness is mounting the witness box, the defense will be having the advantage of his 161 statement recorded by the police officer conducting the investigation. So with reference to that 161 statement, he can be cross-examined, and if any contradiction is there, that can be elicited by the defense lawyer. But in the case of a private complaint, there is no previous investigation. Complainant does not have the power of investigation. Therefore, if without conducting a mandatory inquiry by the magistrate, by examining all the witnesses alleged in the private complaint, and if the case goes up for trial before the court of session pursuant to a committal by the magistrate, the defense will be at a disadvantage in not having any previous statement of the witnesses for the prosecution. That is the reason why there is a mandatory inquiry insisted by the section. There is a full bench decision of the Kerala High Court in Moideen Kutti Haji versus Kunyikoya, 1987 1 KLT 635, corresponding to AIR 1987 Kerala 184, full bench. Full bench held that this is the reason why there is a inquiry mandatorily provided in section 202, that when an offence is exclusively tried by court of session and the case is arising on a private complaint, unless the magistrate conducts an inquiry and examines all the witnesses, the defense will be at a disadvantage in going for trial. Yes, question 8.
Moving on to question number 18.
Yes.
As per clause B of the proviso to section 202 clause 1 CRPC, after excluding a complaint by a court, it is stated that a direction for investigation under section 202 clause 1 can be made only if the complainant and his witnesses, if any, have been examined under section 200 CRPC. Does this proviso apply to a complaint by a public servant who has been exempted from examination under section 200 by virtue of clause A of the proviso to section 200?
Yes. See, clause B of the proviso, after excluding the complaint by a court, it is stated that a direction for investigation under section 202 can be made only if the complainant and his witnesses, if any, have been examined under section 200. But in the case of public servant also similar, same is the position. But if a direction for investigation is to be made, in the case of court, there is a total embargo. But in the case of a public servant, the statement of the complainant and the witnesses should have been examined should have been taken under section 200. A public servant who has been exempted from examination under section 200 is obliged to be examined if the if a direction to the police has to be made. Is there not a contradiction is the question? Yes, while in the case of a complaint by court, no direction for investigation can be given under section 202(1) CRPC. A direction for investigation can be given in respect of all other complainants, including the public servant. A complaint by a public servant. Hence, if a direction for investigation is to be made under section 202 clause 1 CRPC with regard to the complaint made by a public servant, notwithstanding the fact that he has been exempted under section 200, here the court is directing the complaint to the police for investigation, or the complainant and his witnesses will have to be examined. But it is not necessary in the case of a court which has been specifically exempted under the proviso. Yes, there is some difficulty in the case of a public servant. Now we can go to section 19. We have already referred to that, section 2, dismissal of a complaint. Question 19.
Question number 19. Can a complaint be dismissed under section 203 CRPC at the post-cognizance stage?
Yes. In fact, complaint can be dismissed only at the post-cognizance stage, we have already seen. Because complaint cannot be dismissed at the threshold, even if the complaint does not make out any offense. Therefore, I told you that such a complaint can be only rejected, but not dismissed. Yes. Question 20.
Question number 20. If the accused is present in court during the examination of the complainant or his witness under section 200 CRPC or during section 202 inquiry, can he not participate in the proceeding?
See, a private complaint has been filed before a magistrate. Magistrate, after reading the private complaint, decides to proceed under chapter 15. He has taken cognizance. He is recording the sworn statement of the complainant and the witnesses. When their sworn statements are being recorded, the accused happened to be present in court. The accused the accused who is mentioned in the private complaint as the accused, he happens to be present in the court. Can he not participate in the proceedings by cross-examining the complainant and his witnesses? Can he not make submissions before the court? Is the question. He cannot. He cannot, because you are at the pre-process stage. You are at the magistrate is at the pre-process stage. He is either he is about to take cognizance, or he is taking cognizance of the offense by proceeding under chapter 15, either by examining the complainant and the witnesses, or crossing over to section 202 inquiry. During this stage, he has not issued process. He has not proceeded under section 204 CRPC. It is only after recording the sworn statement of the complainant and the witnesses, and after conducting an inquiry under section 202, if necessary, and the magistrate is satisfied that this is a case where the accused should be called upon to answer the charge, and he issues process to the accused, then only the accused gets an invitation to come to the court. Accused has a right to come to the court, or has a business to come to the court, only when he receives a summons or warrant process under section 204. If before the issuance, or before the issue of process, or before the receipt of process, if he happens to be in the court, he can only watch the proceedings. He can be only informed of what is happening in the court. He can only be informed of what is happening in the court. He cannot participate in the proceedings, because he is at the pre-process stage, in contradistinction with a prior complaint warrant trial. If it is a prior complaint warrant trial, there are two stages: before framing charge and after framing charge. On both those stages, the accused can participate, because he has been summoned and he has entered appearance. When the accused has been summoned to the court, he has every business to participate in the proceedings. But here, this is at the pre-process stage. Magistrate is yet to decide whether process should be issued to him or not. At that stage, if he happens to be present in court, he can only remain silent, and he can only be informed of what is happening. If he asks somebody some doubt, a lawyer, he can ask an advocate, what is happening? My name is mentioned. The lawyer can say, this is examination under section 200 or 202 inquiry. You have no business. Are you the accused? Yes, my name is mentioned. You have no business to participate in the proceeding. Even if you engage me, I cannot participate in the proceeding. I can only remain mute. AR 2004 Supreme Court 1492. AR 2004 Supreme Court 1492. Sashi Jaina versus Kadal Swain. Again, in Manhari Bhai, Mulji Bhai Kakadia versus Shailesh Bhai Mohan Bhai Patel, 2012, Volume 10 SEC 517, 3 judges, 517, 3 judges. Both these decisions have categorically held that the accused, even if he is present in court, he cannot participate in the proceedings at the inquiry under section chapter 50. Yes.
Question number 21. Is not the Court of Sessions entitled to directly take cognizance of an offence exclusively triable by a Court of Session, either on a police report or a private complaint, and is there any exception to it?
Yes. Now, a Court of Session can take cognizance of an offence as a court of original jurisdiction only when the case has been committed to the Court of Session under section 193 CRPC. Therefore, the magistrate concerned, the magistrate having jurisdiction, will have to commit the case to the Court of Session, and then only the Court of Session can take cognizance of the offence. Section 193, I will read. Except as otherwise expressly provided by this code or by any other law for the time being in force, no Court of Session shall take cognizance of any offence as a court of original jurisdiction unless the case has been committed to it by a magistrate under this code. Therefore, only when a magistrate commits the case to the Court of Session, the Court of Session can take cognizance of an offence as a court of original jurisdiction. Now, see the opening words. Unless as otherwise expressly provided by this code or by any other law for the time being in force. Now, is there any express provision providing otherwise? there is an express provision providing otherwise. For example, if it is a defamation, if it is a defamation committed against a constitutional functionary, then section 199 2 CRPC says that defamation, because it is being a defamation committed against a constitutional functionary, it is treated as a defamation against the state. Therefore, the public prosecutor before the sessions court concerned can file a private complaint against the offender, alleging that this offender has committed the offense of defamation against a constitutional functionary. Therefore, please take cognizance of offense on my complaint. So that is one case in the CRPC itself, wherein the session judge is entitled to take cognizance without a committal. So, save as expressly provided by this code, this is one express provision, whereby defamation, offense of defamation committed against a constitutional functionary referred to in section 199 2 CRPC, he can be prosecuted, the offender can be prosecuted by means of a private complaint filed by the public prosecutor before the court of session. I recently came across a decision of the Madras High Court wherein it has been held that the public prosecutor will have to be examined under section 200. It's not correct. It's not correct. The public prosecutor need not be examined. Public prosecutor is only a vehicle for filing the private complaint. He need not be examined. The section 237 CRPC has been lost sight of by the Madras High Court. Of course, it is an omission, but otherwise it's a very good judgment, detailing all the previous case law on the point. But there is one mistake committed by the learned judge, that public prosecutor who filed the complaint will have to be examined under section 200 CRPC. Not correct. 237 is the answer. Section 237 CRPC. Therefore, this is one exception provided in the CRPC itself, 193. Then we have, and see, section 193 says, save as otherwise expressly provided by this code or by any other law for the time being in force. Suppose, take for instance, the section 36 1D, section 36 capital A 1D of the Narcotics, Drugs and Psychotropic Substances Act, NDPS Act 1985. That section itself says the special court can take cognizance of an offense under this act without a committal. Without a committal. That means by bypassing 193, section 193. Section 193 can be bypassed by the session court. A private complaint can take cognizance without a committal under section 193, special code. So, save as otherwise expressly provided by this code or by any other law for the time being in force. This is any other law. Again, section 5(1) of the Prevention of Corruption Act. Section 5(1) of the Prevention of Corruption Act 1988 says that the special court may take cognizance of the offense under this act without a committal. Yet another law providing for taking cognizance by a session court without a committal. Again, section 14 of the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act 1989. See, formerly the section 14 of that act says the state government may nominate any court of session to be a special court for trial of offences under this act. Section 14. State government may nominate any court of session. That provision was interpreted by the Kerala High Court, a full bench of the Kerala High Court, to say that since it is a special court which is trying the offence, it can take cognizance without a committal. But that ruling is impliedly overruled by a subsequent ruling of the Supreme Court in Gangula Ashok's case, 2000 Supreme Court, year 2000 Supreme Court, where the Supreme Court, speaking through Justice K.T. Thomas, held that all that the section says is only state government may specify a court of session to be a special court. Therefore, what is specified is only a court of session. It is a court of session, session court, pure and simple. Therefore, it has all the restrictions under section 193 CRP. It can take cognizance of the offence only on a committal. That was the view taken by the Supreme Court. And that decision was holding the field till 2016. From 1/1/2016, the legislature intervened by amending section 14 and said that the special court under the SC/ST Atrocities Act can take cognizance without a committee. So from 1/1/2016 onward, special court can take cognizance without a committee. Yes, now this is only preconditions for initiation of proceedings. That is, now we come to the commencement of proceedings. Question 22.
Yes, sir. Question 22. Is it necessary that initiation of proceedings under Chapter 15 CRPC should precede commencement of proceedings under Chapter 16?
Yes, initiation of proceeding we have seen. When a private complaint is received, magistrate decides to proceed under Chapter 15. He has taken cognizance. That is initiation. After cognizance only commencement of proceedings. Therefore, commencement of the initiation of proceedings should precede the commencement of proceedings in Chapter 16. That is what the CRPC says, and that is what the Supreme Court has also held in SK Sinha versus Chief Enforcement Officer, Videocon International versus SK Sinha Chief Enforcement Officer versus Videocon International, 2008, Volume 2 SCC 492, AR 2008, Supreme Court, 1213, 1213. It is only after the magistrate takes cognizance of offence and does not dismiss the complaint under Section 203 CRPC, does he proceed to issue summons under Section 204 CRPC. Once he issues summons under Section 204 CRPC, it can be said that proceedings have commenced before a criminal court. Then comes the third stage, the trial proper. The trial proper. Every case instituted before a magistrate, either through a private complaint or a police report, we have already seen that. Now, the CRPC has provided different procedure for the trial of summons trial, warrant trial, and session trial. Summons trial can be subdivided into summary trial also. Same summons trial procedure. Now, when does trial begin before a summons? You may read question number 23.
Okay, sir, that exactly is the question. When does the trial begin in summary and summons case?
When after appearance of the accused, either in response to the summons or is produced in response to a warrant, when he is produced or when he appears before court, and when the substance of accusation are read over to him, by the magistrate, courts have taken the view that the trial of a summons case can be said to have commenced. Trial of a summons case can be said to have commenced. Kerala High Court in 1980 KLT 393, corresponding to 1981 Criminal Law Journal 247. Again, 2007 Criminal Law Journal 1626. That the trial of a summons case can be said to have commenced when the substance of accusation have been read over to the accused. Then we come to the warrant trial and session trial, which are again serious trials, serious offences, involving serious offences. Warrant trial involves serious offences. Session trial involves still serious offences. Sorry for the interruption. I got a call. Now, therefore, now we come out to warrant trial and session trial. Now, question 24. You may read question 24. Sunita, question 24 can be read.
Yeah. Question number 24. When does the trial start in warrant and session case?
In the judicial interpretation, judicial definition of commencement of trial in a warrant trial and session trial is when the charge is framed. When the court frames the charge, trial starts, is the judicial interpretation. You may refer to Redilal Bhanji versus State of Maharashtra. Redilal Bhanji versus State of Maharashtra, AR 1979, Supreme Court 984. There are other decisions also. Now, when in a warrant trial instituted on a police report, section 240 is the provision for framing charge. And in a complaint case, instituted on a police report, I'm sorry, in a warrant trial, instituted otherwise than on a police report, section 246 is the provision for framing charge. And in sessions trial, section 228 is the provision for framing charge. Now, if trial starts with the framing of charge, of course, that is the judicially defined situation. Trial in a warrant trial and session trial starts with the framing of charge. I have some reservations about that view, because if trial starts with the framing of charge, why do you find the expression the accused claims to be tried in sections 242(1), 246(4) and 230 CRPC? Because when the in a warrant trial on a police report, or otherwise than on a police report, or in a session trial, when the charge is framed and explained to the accused will say either I plead guilty or I do not plead guilty. If he pleads guilty, the court has to be satisfied that his plea is voluntarily made. So he will have to be given time for reflection. He will have to be told the 164 requirements of safeguards provided under section 164 CRPC will have to be followed by the court. Court will have to tell him, see, you are not bound to plead guilty. Even if you plead guilty, this court will not be lenient towards the sentence, towards you in the matter of sentence. If somebody has advised you to plead guilty and told you that you can be let off with a fine, you are thoroughly mistaken. This is an offense which is punishable with imprisonment. Therefore, I may be inclined to award you even imprisonment. Therefore, don't plead guilty. You are not bound to plead guilty. And even if you plead guilty, don't expect any leniency. You can think over it. Time for reflection has to be given. Then and even after giving time for reflection, if he pleads guilty, then court can straight away convict him. But then there is no trial. That is founded on the principle of section 58 of the Evidence Act. Section 58 says an admitted fact need not be proved. Here is an accused who is admitting the guilt. He says, I did commit this offense. I have the prick of conscience. I don't want to plead not guilty. In which case I will be uttering falsehood before this court. I had committed this offense. I want to plead guilty. Admitted fact. He is admitting the guilt. Therefore, it need not be proved. That is why the court is not conducting any trial. Prosecution is not being called upon to prove the case. Straight away he can be convicted. But take a case where he pleads not guilty. He pleads not guilty and claims to be tried. Charge has been framed and he pleads not guilty and claims to be tried. These are the words occurring in section 242(1), 246(4) and 230 CRPC in all these types of trials. He not only pleads not guilty but claims to be tried, means trial is yet to begin. Claims to be tried. Trial is yet to begin. Again, if you say that with the framing of charge, the trial has begun, what about a case where a sessions judge during preliminary inquiry under section 227 CRPC, pursuant to a committal, after perusing the records and prosecution and the charge sheet, in that the offense is not exclusively triable by a court of session. The precious time of the session court need not be wasted. It is a case which can be tried by the magistrate itself. 307 is the offense mentioned, but actually 307 is not made out. Even by the document produced along with the charge sheet, what is made out is only 326. Therefore, the section 228(1)(a) CRPC entitles the session court to frame charge and transfer the case to the magistrate concerned. So if by framing charge trial has started, how can the session judge transfer the case after commencement of trial? And he is transferring the case for trial after framing charge. Therefore, I have my own reservations, of course, subject to what our apex court may subsequently say. With the framing of charge, trial can never start. After framing charge, the plea of the accused has to be taken. If he pleads guilty, there is no trial. If he pleads not guilty and claims to be tried, then only trial can start. That is my view. Anyway, we are all bound by the decision of the Supreme Court, and so long as that decision holds the field, trial starts with the framing of charge. Yes. Now, pleading guilty. Question 25.
Moving on to question number 25. When the accused pleads guilty, is it an instance of judicial confession, and should the magistrate follow the safeguards provided under section 164, clause 3 and 4 CRPC?
I already answered that. If after framing the charge the accused pleads guilty, magistrate or session court has to be satisfied that the requirements of the safeguards provided under section 164 CRPC have been satisfied. The provisions for pleading guilty are 252 in summons cases, section 252 in summons cases, section 241 in warrant cases instituted on a police report, section 246(3) in warrant cases instituted otherwise than on a police report, and section 229 in session cases, where he pleads guilty. And if the court is satisfied that the plea of guilt has been voluntarily made, knowing fully well the consequences, then the court can straight away convict him. But Kerala High Court, speaking through Justice Padmanabhan, had taken the view that session judges ordinarily should not straight away convict the accused on their pleading guilty, because offences are grave offences and punishment provided is also stringent punishment. Therefore, he will be visited with the stringent punishment on his pleading guilty. That is why the learned judge has taken the view that session judges should not straight away convict the accused. They should call upon the prosecution to prove the case against the accused. Now, with that, we pass on to framing of charge and discharge.
Yes.
I have given you a chart. Can it be screen shared? Chart? Is it possible?
Yes, sir. I am sharing the chart.
Okay, thank you. Yes. Now see, discharge and framing charge. Discharging the accused and framing the charge against the accused. For discharge in warrant trial, chapter 19, discharge can be in a case instituted on a police report. Warrant trial instituted on a police report and instituted otherwise than on a police report. Warrant trial instituted on a police report, the court can discharge under section 239 if the charge against the accused is groundless. The court is of the opinion that the charge against the accused is groundless. In a police charge case, court can straight away discharge the accused instead of framing charge. And in cases instituted otherwise than on a police report, also, if the charge is groundless, 245(2), that is, discharge the accused at any stage. Court can discharge the accused if the court is satisfied that the charge against the accused is groundless. Then under section 245(1), discharge you upon taking all evidence. If after taking all evidence adduced by the complainant, under section 244, no case against the accused is made out, which if unrebutted would warrant his conviction. This is the yardstick. This is the yardstick for discharging the accused in a warrant trial instituted otherwise than on a police report. Two stages. One at any stage, 245(1), then 245(2), then 245(1). After recording all the statements, after taking all the statements, he has to be satisfied about that. That is warrant trial discharge. Then session trial discharge, 227, section 227. Discharge the accused if the judge considers that there is no sufficient ground for proceeding further. There is no sufficient ground for proceeding against the accused after perusing the prosecution records and the all record and the document produced along with the charge sheet, etc. The session judge is of the opinion that there is no ground for proceeding against the accused. He can discharge the accused. Then framing, then 227 proceeding. Then framing charge. For framing charge, warrant trial on a police than on a police report, the yardsticks are same. Same yardstick. Warrant trial for framing charge on a police report or otherwise than on a police report. Police report 241 and otherwise then on a police report section 246(1). If there is ground for presuming that the accused has committed an offence, triable under chapter 19. If there is ground for presuming that the accused has committed an offence, same is the yardstick for sessions trial also. 228(1)(b). Frame charge if there is ground for presuming that the accused has committed an offence which is exclusively triable by a court of session. And if there is no ground for presuming that he has committed an offence exclusively triable by a court of session, as mentioned earlier, the session court can frame charge and transfer the case for trial to the magistrate concerned. These are the broad parameters for discharge and framing charge. Now we pass on to police reports and discharge. Questions on discharge and charge. See, a charge is a written notice. First of all, going to the questions. A charge, what is a charge? A charge is a written notice of the precise and specific accusation against the accused and which he is required to meet. The suitable expression by the Sindh court in AR 1948, Sindh, page 40, beautifully stated. Then again, section 2B CRPC defines the word charge as charge includes any head of charge when the charge contains more heads than one. That is the definition. It's actually not a definition. The necessity of a system of written accusation specifying a definite criminal offence is of the essence of criminal procedure. This was mentioned by the Privy Council in 28 Indian Appeals 257. 28 Indian Appeal 257. Now we pass on to the next question. Question number 26. Punita, you can read question number 26.
Yes, sir. Question number 26. What is the criteria under section 227 CRPC for discharging and under section 228 CRPC for framing a charge against the accused?
See, if you go through the judicial decisions on the parameters for framing charge and discharging the accused, confusion confounded. We have seen simple, very simple expressions, is it not? For discharging in a warrant trial, if the discharge the accused if the charge is groundless, is it not? And session trial also, if there is ground for presuming that the accused has committed an offence, you frame charge, otherwise you discharge. But when you come to the case law, very confusing, perplexing case law. I will give you the citations one after the other. Various parameters have been laid down by our apex court. Union of India versus Prafulla Kumar Samal and another. 1979, volume 3 SCC 4, corresponding to AR 1979 Supreme Court 366. Charge can be framed if there is a prima facie case, as in the case of granting temporary injunction. That's a prima facie case. Court can frame charge. One yardstick. Again, that has been repeated in AR 1986 Supreme Court 2045, AR 1987 Supreme Court 773, even 2000 AR 2001 Supreme Court 40. Charge can be framed if there is a prima facie case. Then charge can be framed. Yet another parameter. Charge can be framed only if there is a grave or strong suspicion that the accused committed the offence. Not mere suspicion, grave or strong suspicion that the accused committed the offence. AR 1979 Supreme Court 366. Again, AR 2009 Supreme Court 2195. Yet another parameter. Court will be justified in discharging the accused if the evidence produced gives rise to some suspicion. If there is only some suspicion, court can discharge. Court will not frame charge. In other words, mere suspicion is enough for discharging the accused. Or some suspicion, it can discharge the accused. But if there is grave suspicion or strong suspicion, court has to frame charge. AR 2002 Supreme Court 564. Again, AR 2008 Supreme Court 2991. AR 2009 Supreme Court page 9. Yet another parameter. Holding a mini trial at the stage of framing charge or discharging is to be avoided. Don't conduct a mini trial. You consider these parameters and decide whether the accused is to be discharged or whether a charge has to be framed. 2005, 1 SEC 568. Again, 2009, AR 2009, Supreme Court 976. You can't conduct a mini trial. Your trial is yet to begin once you frame charge. Therefore, you don't conduct a mini trial before the actual trial. Then, yet another parameter. Even if the court thinks that the accused might have committed the offense, charge can be framed. Accused might have committed. State of Maharashtra versus Somnath Thapa. AR 1996, Supreme Court 1744, 3 judges. 1744, 3 judges. Yet another criterion. Possibility as against certainty is sufficient for framing charge. There need not be any certainty. Possibility of a conviction is enough for framing charge. AR 2007, Supreme Court 2149. AR 2009, Supreme Court Supplemental 523. Mere possibility is enough for framing charge. Earlier they said suspicion, grave suspicion should be there for framing charge. Strong suspicion should be there. Now says a possibility is sufficient for framing charge. Then, at the time of framing charge, the materials produced by the prosecution have to be accepted as true. The probative value of those materials cannot be gone into at that stage. So prosecution materials will have to be accepted as true. You don't consider the probative value or the truth or otherwise of those materials. AR 2007, Supreme Court 2149. Then, it is immaterial whether the case is based on circumstantial evidence or direct evidence. Direct or circumstantial evidence, whatever may be it can be considered at that stage. There need not be any direct evidence. 2004, AR 2004, Supreme Court 3967. Again, 2014, Volume 3, SCC, Criminal 529. SCC Criminal 529. Then, again, reiteration of the earlier position. Analysis of all the materials by deciding the pros and cons or reliability or acceptability of those materials not to be undertaken at that stage. AR 2000, Supreme Court 3330. AR 2000, Supreme Court 3330. Again, 2010, Volume 9, SEC 368. Then, yet another order should not be one virtually passing an order of acquittal in the garb of discharge. In an appropriate case, you may discharge the accused, but it should not be virtually an order of acquittal under the garb of discharge. You have that is by considering the pros and cons, going into the acceptability of the materials, etc. After a thorough examination, mini trial, virtually conducting a mini trial, you cannot pass a discharge order which will have the effect of a virtual acquittal. 2009, 10 SCC 429. At the stage of framing charge, the court is concerned only with the question as to whether prima facie case appears and the existence of any material. Court need only consider whether there is material existing. Not the sufficiency of those materials. Court need only consider whether there is any material in support of the allegation. The sufficiency of the material need not be gone into at that stage. Para 45 of Prakash Singh Badal, AR 2007, Supreme Court 1274. With the result, in the light of all these judicial pronouncements, it is easier for any court either to discharge an accused or frame charge. You have conflicting decisions on every point. So, after all, the legislature had used the simple expression whether there is sufficient ground for presuming that the accused has committed an offense, or whether there is sufficient ground for proceeding against the accused, or whether the charge is groundless. These are the expressions used by the legislature. But the interpretation, going by the interpretation, in a given case you can discharge the accused, and with the same material you can frame charge also. applying these rulings. So in a way, it is useful for judicial officers, for judges. So if they want to discharge an accused, even if there is material in support of the charge, they can apply one of these criteria. But will it be doing justice is another question. Question 27.
Question number 27. What is the object of charge?
What is the object of framing charge? The object of framing charge is to warn the accused person of the case he has to answer. It cannot be treated as if it were part of a ceremonial. This is what the Supreme Court said in B.N. Srikantayya versus State of Mysore, AR 1958, Supreme Court 672, question 28.
In the charge curable.
Supposing the charge is imperfect, is it curable? Yes, it is curable. Imperfection, provided no prejudice or failure of justice has been occasioned to the accused, it is curable. Again, AR 1958, Supreme Court 672, 2010, Volume 1, SEC 94. Question 29.
Question number 29. What are the contents of the charge framed by the court?
Section 211 CRPC deals with the form of charge and contents of charge. The form of charge referred to in section 211 is to be found in form number 32 of the second schedule to the CRPC. It reveals that the details of each offences are to be stated with reference to the particular accused who committed the offences and the person against whom such offence were committed. Supposing there is a plurality of accused, the role played by each of the accused will have, if available, will have to be mentioned in the charge, and the victim, the name of the victim against whom he had committed those offences will have to be mentioned in the charge. There's a decision, beautiful decision by State of Kerala, Rameshan versus State of Kerala, 2007, Criminal Law Journal, 1637. Criminal Law Journal, 1637. Question 30.
Question number 30. Is not the non-framing of charge fatal?
You may refer to section 215. Before answering this question, section 215. Please read section 215. Can you access that?
Yeah, sure, sir.
215.
Yeah, sure. So 1 second.
Yes.
Section 215. Effect of errors.
Yes.
No error in stating either the offense or the particulars required to be stated in the charge, and no omission to state the offense or those particulars shall be regarded at any stage of the case as material, unless the accused was in fact misled by such error or omission and it has occasioned a failure of justice.
Then please read section 464.
Section 464. Effect of omission to frame or absence of or error in charge. No finding, sentence, or order by a court of competent jurisdiction shall be deemed invalid merely on the ground that no charge was framed or on the ground of any error.
On the ground that no charge was framed, not merely irregularity. So this is for the superior courts to consider. When there is already a conviction by a lower court, the question whether no charge was framed, even that is not an issue before a superior court. Yes. Or that.
Or irregularity in the charge, including any misjoinder of charges, unless, in the opinion of the Court of Appeal, confirmation or revision, a failure of justice has in fact been occasioned thereby.
Yes. Therefore, the technical defect in the charge can be cured, and that will not vitiate the trial, just because the non-framing of a charge cannot vitiate the trial unless the accused has suffered prejudice. Oh, You may refer to AIR 2010 Supreme Court 3786. AIR 2010 Supreme Court 3786. Question 31.
Question number 31 is
Yes.
not a technical defect in the charge material.
Again, same answer. Technical defect in the charge is not material. It's a curable irregularity only. Not, it will not go to the root of the matter, affecting the jurisdiction of the court. Unless, of course, if the accused is able to show that he has suffered prejudice. It is not here merely. It is not enough that he merely mentions that I suffered prejudice. What exactly is the prejudice suffered by him will have to be shown by him, proved by him. 1999 volume 5 SEC 253. 32.
Question number 32. Is it not proof of the materials relied on by the prosecution which is relevant for establishing the validity of the charge?
See, for deciding the validity of a charge, the question is whether proof of the materials relied on by the prosecution, is it relevant? Certainly not relevant. It is the allegation. It is the allegation which is relevant. Proof comes only thereafter. Yes, AR 1975 Supreme Court 1309, 3 judges. Question 33.
Question number 33. At the stage of framing charge, is it not necessary for the court to meticulously consider the evidence and other materials produced by the prosecution?
Again, same answer. You are not examining the evidence. The meticulous examination of the evidence is to be avoided. We have already seen a mini trial should be avoided. Under the garb of discharge, you cannot pass virtually an order of acquittal. You cannot examine the reliability or otherwise of the entire material. And after referring to the entire material, the pros and cons of each and every material, you cannot pass a detailed order running into pages and discharge the accused. It will have the effect of an acquittal, an acquittal under the garb of discharge. Yes, 1981, AR 1981 Supreme Court 1548. Again, AR 2001 Supreme Court 222. That was the case under the PC Act. Yes, question 34.
Question number 34. When a wrong section is mentioned in the FIR, is it permissible for the court state the appropriate section while framing charge?
Yes, just because a wrong mentioned is mentioned in the FIR, that will not preclude the court from mentioning the correct provision of law while framing charge. Because by framing charge, you are putting the accused to notice as to the case which he has to meet. That is AR 2003 Supreme Court 4140. AR 2003 Supreme Court 4140. Question 35.
Question number 35. Accused is convicted under section 302 IPC. Is it not permissible for the court to convict the accused for the offense punishable under section 307 read with section 34 IPC also in connection with the same murder?
See, you for the same act of murder, you are convicting him for 302. Then for the same act, you cannot convict him under section 307 as well. That is what the Supreme Court said in AR 1993 Supreme Court 2448. 2448. Yes. Question 2036.
Yeah, okay, sir. Question number 36. Even though the recitals in the charge have stated that the main object of the criminal conspiracy was cheating by impersonation, in the charge under section 419 IPC, there is no specific mention of cheating by personation. Is it not the accused justified in contending that he was charged for cheating simpliciter?
See, in the charge framed under 419, there is an allegation, there is a reciter in the charge that there was cheating by impersonation. Even though specific charge under section 417 was omitted to be made. So that will not prejudice the accused. Therefore, just because 417 has not been specifically pleaded, the accused cannot put forward the contention that he was prejudiced. Therefore, Supreme Court said that there is no question of any prejudice in such a case when the averment of impersonation has been recited in the charge, though not specific offense under section 417 has not been made. AR 1977 Supreme Court 2433, 3 judges. Question 37.
Question number 37. What is the distinction between common intention under section 34 IPC and common object under section 149 IPC?
Now, these are the usual sections invoked for bringing about vicarious liability, which itself is not a correct expression. Anyway, vicarious liability is it has come to stay. Common intention implies a pre-arranged plan and acting in concert pursuant to the said plan. Such pre-concert or pre-planning may develop on the spot or during the course of commission of the offense, but certainly it has to precede the actual commission of the offense. Kripal versus State of UP, AR 1954, Supreme Court 706. The crucial test is that such pre-arranged plan must precede the act of constituting the offense. The very act of constituting the offense should be subsequent. AR 2001, Supreme Court 1344, 3 judges. Common intention means each member of the group is aware of the act to be committed. Common intention, persons acting in prosecution of the common intention means each member of the group aware of the act to be committed. That is 2010 10 SEC, volume 10 SEC 259. While common object referred to in section 149 IPC is different from common intention, as it does not require a prior concert and a common meeting of minds before the attack. It is enough if each has the same object in view and 5 or more persons act as an assembly to achieve that object. Sunil Kumar versus State of Rajasthan, AR 2005, Supreme Court 1096. Commission of overt act is not necessary on the part of every member of the unlawful assembly. All members of the unlawful assembly, there need not be any overt act except one. Even one is enough. Karudin versus State of West Bengal, 2000, AR 2013, Supreme Court 2354. Mere presence or association with other members alone does not per se become sufficient to hold every one of them criminally liable for the offense committed by the others, unless there is sufficient evidence on record to show that each of them intended or knew the likelihood of the commission of the offense. Then only you can say that they shared the common object of that assembly. A mere bystander, a mere onlooker cannot be roped in by section 149 and committed and convicted for the offense. Ramachandran versus State of Kerala, AR 2000, Supreme Court 3581. Now, if you peruse section 141 IPC, that is being member of an unlawful assembly, please read one. Can you IPC? You have IPC with you? Or I will read, no problem. I can read.
So I do have.
Okay. 141.
1 second, sir.
Unlawful assembly. No problem, I will read. No problem.
Yes, sir.
Unlawful assembly 141. An assembly of 5 or more persons is designated an unlawful assembly if the common object of the persons composing that assembly is first to overawe by criminal force or show of criminal force the central or any state government or parliament or the legislature of any state or any public servant in the exercise of lawful power of such public servant, or second to resist the execution of any law or any legal process, or third to commit any mischief or criminal trespass or other offenses. So these are, see, other offenses. The offenses have not been mentioned. Fourth also does not take in the offenses. Fourth and fifth also will not take in other. These other offenses means should they be read ejusdem generis with the earlier offenses, namely criminal force or show of criminal force. I'm sorry, the mischief or criminal trespass. mischief or criminal trespass or other offences. So should the word other offences take the color of mischief or criminal trespass by applying the rule of ejusdem generis? That was the question posed by the Supreme Court. And in 2013, AR 2013 Supreme Court 2354, that is, I'm sorry, it's not 23. No. Manga. 2013, volume 7, SEC 629. Manga versus State of Uttarakhand. The Supreme Court held that the definition of offense in section 40 IPC will have to be imported when you say other offense. It need not be, it cannot be read ejusdem generis. And they also imported the words likely to cause death occurring in section 148 IPC also as an indicator to show that the rule of ejusdem generis was foreclosed. Therefore, they said that other offense occurring in thirdly of section 141 can include any other offense as defined under section 40 of the Indian Penal Code. And to buttress that view, they also took into consideration the words likely to cause death in section 148 of the Indian Penal Code. Manga versus State of Uttarakhand, 2013, 7 SEC 629. Now, basically, if the object of the common object of the unlawful assembly was to give a beating, supposing all of them assembled and the object was to give a beating to the accused, and if any one of them made a frolic, was on a frolic of his own, he made a fatal stab, you cannot say that the others shared that common object. The common object was only to give a beating, and if any one of them made a lethal stab, the others cannot be said that they shared the common object of that assembly. Basically, this is the principle under section 149. Question 38.
Against 5 named accused persons for the offense of murder under section 302, read with section 149 IPC, and if 2 out of the above 5 persons are acquitted, can the surviving 3 accused persons be convicted for murder under section 302, read with section 149 IPC, or under section 302 simpliciter?
Where a charge has been framed against 5 named accused persons for the offense of murder under section 302, read with section 149, and if 2 of the above 5 persons are acquitted, then the charge under section 302, read with section 149 cannot be sustained as against the remaining 3 accused persons, since with the acquittal of 2 persons, there is no unlawful assembly, because 5 or more persons should be there. 141, we have seen that. If on the contrary, the charge against them was that some other known or unknown persons, apart from the specifically named accused persons, some known or unknown persons were also involved. In such a case, if that is the charge, and if the number gets reduced to 3 or 2, less than 5, then also there is no problem. Court can nevertheless convict them with the aid of section 149. But if the charge was specifically for 5, with regard to 5 named persons, and if the number of accused persons comes reduced to 2 or 3, less than 5, then you cannot convict them with the aid of section 149, which 149 presupposes the involvement of 5 or more persons. 1993, volume 3 SEC 32, Subbaran versus State of Kerala. 1993, volume 3 SEC 32. Question 39.
Question number 39. Is it permissible for the trial court, on a consideration of the broad probabilities of the case and based upon the total effect of the evidence and documents produced, to decide to add to or to alter the charge?
Yes, there is no bar. The court can. There is no legal bar. A court can appropriately act as the exigencies of the case demand. You may refer to AR 2012 Supreme Court 3026. Again, 2004 Supreme Court 2078. AR 2004 Supreme Court 2078. Question 40. Question 40. Hello.
Number 40. Can the appellate court add to or alter the charge?
Can the appellate court add to or alter the charge? Appellate court also can add to or alter the charge. Section 385 reduce Section 386 E, Section 386 E CRPC. 2012, Volume 9 SEC 650. Again, year 1970, Supreme Court 359. Yes, question 41.
Question number 41. What do you mean by prejudice?
When the accused alleges prejudice, it has to be shown that the accused has suffered some disability or detriment in the protections available to him under the Indian criminal jurisprudence, and that this has occasioned failure of justice. Wherever a plea of prejudice is raised by the accused, it must be examined with reference to the above rights and safeguards of the accused, and whether it is in violation of those rights alone, and it is in violation of those rights alone that that may result in weakening of the case of the prosecution, and benefit may go to the accused. The plea of prejudice has to be in relation to investigation or trial, and not in relation to matters falling beyond their scope. This was so held by the Supreme Court in AR 1957 Supreme Court 320. Again, 2011 Volume 8 SEC 300. Question 42.
Question number 42. What is meant by failure of justice?
If you read 464, unless it has occasioned prejudice or failure of justice, that is the word used by Section 464. What is meant by failure of justice is the question. One of the cardinal principles of natural justice is that no man shall be condemned unheard. Audio alterum partem. Before courts, but courts often hesitate to approve the contention that failure of justice has occurred merely because a person was not heard on a particular aspect. However, if the aspect is of such a nature that non-explanation of it has contributed to penalizing an individual, the court should say that since he was not given an opportunity to explain that aspect, there was failure of justice on account of non-compliance with the principles of natural justice. So everything depends on the consequence which the accused is visited with due to the failure to give an explanation, failure to give a hearing. Shamsheb versus M. Multani versus State of Karnataka. AR 2001 Supreme Court 921. 3 judges. Question 43.
Question number 43. Will not a defect in the language or in the narration or in the form of charge render the conviction bad?
No, unless the accused is able to show he has suffered prejudice on account of that. 2010, Volume 1, SEC 94. Question 44.
Question number 44. What is the criteria under Section 227 CRPC for discharging and under Section 228 CRPC for framing a charge against the accused?
Yes. For framing of charge, ground for presuming that the accused has committed the offense is the criterion. And for discharging, there is a mere suspicion, etc. I have already given the citation, various decisions giving various parameters. You can use appropriately, whether you are the defense counsel or the prosecutor, or whether you are the presiding judge. You can use the citation appropriately. That one way that the case law has helped us, because you have different yardsticks, different parameters, which can be appropriately used by the court, defense lawyer, or the prosecutor, depending on the facts and circumstances of each and every case. Yes, 45.
Question number 45. The defense contends that since Section 149 IPC creates a distinct and separate offense, conviction of the accused with the aid of Section 149 is unsustainable in the absence of a specific charge under Section 149. Is the said contention sound?
The apex court has held that it is not a sound contention. We have already seen that even the absence of a charge may not vitiate the conviction. Therefore, if the evidence discloses that particular accused persons assembled together, armed with deadly weapons, etc., and they shared the common object of the assembly, then the defect, the specific absence of a charge under 149 will not be fatal, because the aberments which bring the case under section 149 are there in the charge. 2009 AR 2009 Supreme Court 2661. Question 46.
Question number 46. Since section 216 CRPC enables the court to alter or add to the charge, is it not permissible for the court to allow an application under section 216 CRPC in respect of an accused who has already been discharged?
The section 216 says court may at any stage before judgment may alter the charge. Here is an accused who has been discharged. Why not? Is it not permissible for the court to alter the charge? Under section 216. See, he has already been discharged. In the case of an accused who has been discharged, there is no question of altering the charge. There is no charge. He has been discharged. Therefore, there is no question of altering the charge in respect of an accused who has already been discharged. AR 1990 Supreme Court 2158. Please bear that in mind. With regard to the discharged accused, the prosecutor or the court cannot take shelter under section 216 for altering the charge as against him. He stands discharged. He has gone out of the case. Yes. 47.
Question number 47. Does it not follow that the trial has to commence de novo after the addition or alteration of charge?
Not always. Not always. It depends on the discretion of the court. Depending on the and unless there is a specific order, there cannot be a de novo trial. It all depends on the discretion of the court. And if the court finds that there is a further charge has to be framed and evidence has to come on that charge, and that will not suffice, matter has to come a de novo trial. Then only court can order de novo trial, not otherwise. AR 1995 Supreme Court 1219. 48.
Yes, sir. 48.
Yes.
Accused was convicted under section 302 IPC, read with section 34 IPC, without a charge under section 34 IPC. The reason given in support of the conviction is that common intention can be formed at the spot and inference regarding such common intention can be drawn even in the absence of evidence of pre-concert of minds. Is the conviction sustainable?
Yes, if there is a evidence of meeting of mind, evidence of meeting of mind, then even without a charge, a conviction under section 302 with the aid of section 34 can be made. That's what the Supreme Court said. If there is evidence, provided there is evidence of meeting of minds and predetermination of minds. 2001 Supreme Court 3853. Question 49.
Yes, sir. Question number 49. A1 to A3 were charged under section 302 and 201, read with section 34 IPC. A2 and A3 were acquitted of the charge under section 302, read with section 34 IPC. Can A1 alone be convicted under section 302 IPC simpliciter without an independent charge under section 302 IPC?
So the prosecution case is that all the three in prosecution of the common intention committed the offense. Is it not? So when any one of them commits the offense, the rest of them are also presumed to have individually committed the offense. So supposing out of the three, two have been acquitted, is it not permissible for the court to convict the remaining three with the aid of section 34? The remaining one accused person with the aid of section 34. When 2 out of 3 have been acquitted, there is no question of any common intention. There is no question of any common intention. The surviving accused can be convicted only if there is evidence to show that he was the person who committed the offending act. Then only he can be convicted under section 302. AR 1990 Supreme Court 2140. Because you cannot invoke the principle of common intention and convict him when the other participants have been acquitted. then there is no question of any common intention. So you cannot convict him with the aid of section 34 also. So he can be convicted under section 302 only if it is shown that he was the solitary person who actually committed the murder. So that if the others were also tried along with him for not committing the murder, they can be convicted for murder because they had the common intention. But even though they were non-participants in the act of committing murder, that distinction has to be borne in mind. Question 50.
Question number 50. What do you mean by misjoinder of charges?
Section 218 CRPC is under the heading joinder of charges. Therefore, if joinder of charges is in contravention of the procedure prescribed under section 218, it would amount to misjoinder of charges. Kamalananda versus State of Tamil Nadu, AR 2005 Supreme Court 2132. 51. Question 51.
Question number 51. What is the object of section 218 CRPC?
The object of section 218 CRPC is to save the accused from being embarrassed in his defense if distinct offences are lumped together in one charge and or in a separate charge and tried together. AR 1954 Supreme Court 436. Now you may notice that section 218 CRPC lays down the principle of separate charges for distinct offences. The rule under 218 is that there should be separate charges for distinct offences, and there are 4 exceptions. One is section 219, where 3 offences of the same kind within 1 year may be charged together. An offence, it is an exception to 218. Again, 220, more than one offence committed during same transaction may be charged at the same trial. Second exception to section 218. Third exception is 221, where it is doubtful as to what offence has been committed. Then last exception is section 223. Class of persons who may be charged jointly. The class of persons who may be charged jointly. That is also an exception to 280. Yes. To question 52.
Question number 52. What is the meaning of same transaction occurring in section 220 and 223 CRPC?
Now, those are the sections which mention that if offences have been committed by more than one individual as part of the same transaction, or more offences than one have been committed as part of the same transaction, they can be charged for the offence. Same trial. To constitute same transaction, the series of facts alleged against the accused must be connected together in some way by proximity of time, unity of place, unity or community of purpose or design, and continuity of action until the series of acts or group of connected acts come to an end. Until they come to an end, they can be treated as part of the same transaction. That is the meaning given by the Supreme Court in Chimalapati Ganeshwara Rao, State of AP versus Chimalapati Ganeshwara Rao, AR 1963 Supreme Court 1850. Question 53.
Question number 53. What
Yes.
is a minor offense within the meaning of section 222 CRPC?
Minor offense under section 220 to 222 CRPC has not been defined in the CRPC, but it can be discerned from the context that the test of minor offense is merely that the prescribed punishment is less than the major offense. That is not merely the test. The 2 illustrations provide the section in the section will bring the above point home. Only if 2 offenses are cognate offenses, if they are cognate offenses wherein the main ingredients are common. If the main ingredients of both the offenses are common, the one punishable among them with a lesser sentence can be regarded as a minor punishment, minor offense. So main ingredients should be common. They should be cognate offenses, and if one of them is punishable with a lesser sentence, then it is a minor offense for the purpose of section 222 CRPC. Shabna Sahib versus M. Multani versus State of Karnataka, 2001, Volume 2, SEC 577. Question 54.
Question number 54. When the main offense with which the accused is charged is murder, can he not be convicted of an offense under section 411 IPC, that is dishonestly receiving stolen property, by applying section 222 clause 2 CRPC?
Applying the earlier test, 411 cannot be treated as a minor offense for 302 because 222, it violates section 222, which is neither a cognate offense nor common ingredient are also absent. Therefore, cannot be done. V. Thomachan versus State of Kerala, 1978 Criminal Law Journal 498, Kerala High Court. Question 55.
Question number 55. Where the accused is acquitted of an offense of a higher degree, can he be convicted for a lesser offense?
Yes, by virtue of section 222, if it falls under section 222, he can be. K. Prema S. Rao versus Yatla Srinivas Rao, 2003, 1 SEC, volume 1 SEC, 217, 56. Question 56.
Number 56. Is it not permissible for the accused to demand as of right his trial with co-accused under section 223 CRPC?
No, he cannot demand as of right. He cannot demand as of right under section 223. A.R. Andule versus R.S. Nayak, Constitution Bench, 1988 2 SEC 602. 1988 2 SEC 602. A.R. Andule versus R.S. Nayak. Question 57.
57. Is not a conviction and sentence recorded by the court in a joint trial invalid?
No, it's not. It cannot be invalid in the absence of proof of failure of justice. Premchand versus State of Haryana, 1989, Supplementary 1 SEC 286. Yes. Question next 58.
Moving on to 58. The charge is conspiracy to commit an offense followed by a charge in respect of that offense as well. Conspiracy is not established and the accused is acquitted of the offense of conspiracy. Can the accused be convicted in respect of the substantive offense?
See, they conspire to commit an offense. Conspiracy is, what is the question? Conspiracy is not established. So you will have to be acquitted for conspiracy. But what about the other offense? If there is evidence of the other offense having been committed, he can be convicted. 2000 AR 2004 Supreme Court 1242. 1242. Question 59.
Next question. The charge is criminal conspiracy to commit a particular offense.
Yes.
Prosecution failed to prove that particular offense. Can
Yes.
there be a conviction for criminal conspiracy alone?
Yes. They conspired to commit a particular offense. That particular offense was not committed, or rather, there is no evidence of that particular offense committed pursuant to the criminal conspiracy. So, can he be convicted for criminal conspiracy alone, for which the other offense was not committed? The criminal conspiracy punishable under section 120B is an independent section. Therefore, there can be a conviction under section 120B, notwithstanding the fact that the offense for which they conspired, the conspiracy was not committed. 2009, 11 SEC 737. 60.
Moving on to next question. The overt acts committed pursuant to the criminal conspiracy were committed beyond the jurisdiction of the court having jurisdiction to try the offense of criminal conspiracy. Can that court try the other offenses?
The conspiracy was committed within the territorial limits of the court, but the other offenses are committed beyond the territorial limits of the court. So, can the court convict the accused for committing the other offenses? Other offenses were committed beyond the territorial limits of the court. They can be convicted. It is a cause and effect of the conspiracy. 1962 Supreme Court, AR 1962 Supreme Court, 1821. Yes.
Next question.
61.
Yeah, 61. Court is having jurisdiction to try the offenses committed in pursuance of the criminal conspiracy, but the offense of criminal conspiracy was committed outside its territorial limits. Can that court also try the offense of criminal conspiracy?
The converse of the earlier question. Here, the court is having jurisdiction to try the offense committed in pursuance of the conspiracy, but conspiracy was committed beyond the territorial limits of the court. Same position. AR 1961 Supreme Court 1601, 1601. AR 1961, Supreme Court 1601. It has to be considered as a cause and effect of the conspiracy. Yes. Question 62.
Question number 62. In a charge for offences punishable under section 498A and 304B IPC against the accused for subjecting his deceased wife to such cruelty and harassment as to drive her to commit suicide, is it permissible for the court to convict the accused without a specific charge for an offence punishable under section 306 IPC by drawing the presumption under section 113A of the Evidence Act along with or instead of section 498A IPC in a case where the offence under section 304B has not been proved?
304B is dowry death. That has not been proved. And but there was evidence of accused subjecting the deceased wife to cruelty and harassment of such a degree as to drive her to commit suicide. So courts held that even without a charge under section 306, the accused can be convicted under section 306 by drawing the presumption under section 113A of the Evidence Act. Section 221 CRPC enables such a course. AR 2003 Supreme Court 11. Again AR 2011. Not AR 2011 Volume 2 SEC 47. AR 2000. I am sorry. 2008 Volume 14 SEC. 2008 Volume 14 SEC 94. There are any other decisions also. It is permissible by virtue of this, the power under section 221 CR. Yes. 63.
Question number 63. In an altercation between the husband and wife not involving any demand for money or property, the husband, in response to a retort by the wife, slaps her on the cheek. She lodges a complaint before the police, who eventually charge sheets the husband for an offence punishable under section 498A IPC. The husband pleads for a discharge before the magistrate. Can he succeed?
See, can you read 498A IPC?
Sure, 1 second. (498A).
Yes.
Husband or relative of husband of a woman subjecting her to cruelty.
Yes.
Whoever, being the husband or the relative of the husband of a woman, subjects such woman to cruelty shall be punished with imprisonment for a term which may extend to 3 years and shall also be liable to fine.
So subjects a woman to cruelty is the main part of this offense. Now what is exactly say cruelty has been explained in the explanation. Please read the explanation.
For the purpose of this section, cruelty means any willful conduct which is of such a nature as is likely to drive the woman to commit suicide or to cause grave injury or danger to life, limb or health, whether mental or physical, of the woman, or harassment of the woman.
Anyway, that is not applicable here. There is no demand for dowry. But cruelty, any willful conduct which is of such a nature as is likely to drive the woman to commit suicide or to cause grave injury or danger to life, limb or health of the woman. See, cruelty should be of such a nature as to drive her to commit suicide or to commit any injury, grave injury to her, any grave injury or danger to life, limb or health of the woman. Therefore, if you strictly apply section 498, a husband slapping his wife cannot amount to 498A. It may amount to 323, or depending on the type of hurt committed, it may be 324, etc. But it can never be 498A, because cruelty for the purpose of 498A means any willful conduct which is of such a nature as is likely to drive the woman to commit suicide or to cause grave injury. It should be the woman who commits that. Therefore, supposing the husband slaps her and unable to endure the humiliation or pain, she cuts her vein. His willful conduct has driven her to commit that cutting of vein. She has done that. That is the willful conduct which is contemplated by the explanation A to section 498. Otherwise, slapping the wife may be 323 or 324. That may be different offense, and there is a different offense under the IPC, not 498A. 498A can be invoked only where the husband, willful conduct of the husband is such a nature as to drive her to commit an offense, to suicide or some any other grave injury or danger to her life. That is, she has to do that, unable to bear with the willful conduct of the husband. Then only the section will be attracted. Otherwise, for other willful conduct, there is IPC offences are there. That's one decision of a subordinate court in Kerala. It is yet to reach the High Court. Therefore, you can't cite it as a precedent. Yes. Question next.
Next question. Question number 64. The charge is that the accused committed murder punishable under section 302 IPC and also caused disappearance of the evidence of murder punishable under section 201 IPC. Accused is acquitted of the offense of murder. Can he be convicted under section 201 IPC?
The specific charge is that she committed the murder of her husband. Committed murder. Accused committed murder, 302, and caused disappearance of the evidence. Accused is acquitted of it. Actually, it is a case of a wife committing murder of her husband. That was the case. Actually, I was having that in contemplation. See, an advocate practicing in the Kerala, he was a drunkard who used to pick up quarrels for each and everything while at home under the influence of alcohol. One day, he was found dead. The wife was convicted, was charged for murder of her husband. What is the one word for causing murder of the husband? For causing murder of the wife, there is a one word. Uxoricide. Uxoricide is husband killing the wife, which is the one word for wife killing the husband. Mariticide. Mariticide is the one word for wife killing the husband. So she was charged for mariticide, and also 201, that is for causing disappearance of the evidence of murder. Now the trial court acquitted her of the charge of murder, but convicted her for 201, causing disappearance of the evidence of murder. Challenging the conviction for 201, 201 she was convicted, but 302 she was acquitted. Challenging the conviction under section 201, she filed an appeal before the High Court and argued that I have been acquitted of the charge of murder. Then where is the question of my causing disappearance of the evidence of murder? When the specific finding of the lower court is that I did not commit murder, then where is my committing the evidence of causing disappearance of my committing 201, section 201 IPC, causing disappearance of the evidence of murder? That argument was repelled by the High Court by holding that notwithstanding the acquittal for murder, a person can be convicted for causing disappearance of the evidence of murder. 201, and in fact there is another, in another case, Supreme Court also has taken the same view. This decision was rendered by the Kerala High Court in 1991, 1 KLT 503 by Justice K.T. Thomas. Subsequently, in another case, Supreme Court has also taken the same view. AIR 2007 Supreme Court 3050. The trial judge in this case was one Mr. K. Ramachandran, who after retirement is now practicing in the High Court. He had given me some matter to be furnished to the LiveLaw. I'll do that after the lecture. He had his own views about some certain aspects of framing charge. According to him, he told me that in the exercise of framing charge, the defense counsel as well as the prosecutor should be heard, or rather their views also should be considered by the court. Nothing wrong. But then will the defense lawyer will he give any suggestion to fill up the loopholes in the charge? Will the defense lawyer give any suggestion to fill up the loopholes in the charge, if any, framed by the court? And prosecutors, they don't assist the court at the time of framing charge. They assist the court only during trial. Even in appeals, they don't assist the court. Criminal appeal, they don't assist the court. Yes, we will pass on to the next question. 65.
Under section 302 read with section 149 IPC, can they be convicted for section 302 with the aid of section 109 IPC without a specific charge under section 109 IPC?
302 with 149 as part of the unlawful assembly, as member of the unlawful assembly, he is charged under 302 under 1 and read with 149. Question is whether he, instead of 149, can he be convicted for 302 read with 109, that is abetment of murder. 109 he cannot be, because 109 is an independent separate charge, is a separate offense, independent offense, distinct offense. Therefore, he cannot be convicted for 302 read with 109 without a charge. 2000 volume 10 SEC 50. 2000 volume 10 SEC 500. Again, year 1995 Supreme Court 4. Year 1995 Supreme Court page 4. Question 66.
Question number 66. Where the accused in a murder case are acquitted of the charge under section 148 IPC, which is the only offense relating to constructive liability charged under the charge against the accused, can they be convicted under section 302 read with section 149 IPC in the absence of a charge under section 149 IPC?
See, even though section 148 is also an offense committed by a member of an unlawful assembly armed with deadly weapons, Supreme Court took the view that if that is not sufficient for convicting him under section 302 read with section 149 in the absence of a charge under section 149. 148 will not suffice. That is the view taken by the Supreme Court. 2010 volume 1 SEC 94. Supreme Court said it is impermissible to do that, to convict the accused under 302 by calling into aid section 149 without a charge. 148 charge, often charge under 148 is not sufficient. Question 67.
Question number 67. Is not the court entitled to convict the accused for an offense punishable under section 304B IPC by resort to section 222 CRPC in a case where the charge is under section 302 IPC?
The charge is under section 302 IPC. 304B, dowry death, cannot be treated as a cognate and minor offense when compared to section 302. 304B is not a cognate or minor offense when compared to section 302 IPC. Some Multani versus State of Karnataka. Year 2001 Supreme Court 921. Not permissible. 68.
Question number 68. Accused persons face trial for charge under section 211, 250, 216, 280, 221 and 464 IPC. There was no charge under section 334 IPC. Court convicted them with the aid of section 34 IPC. Is it legal?
Nothing wrong if the evidence discloses a preconcert of mind and acting in prosecution of the common intention of the group of persons, unless the accused is able to show prejudice. The want of a charge under section 34 will not be fatal to the prosecution. 2010 volume 10 SEC 259. Question 69.
Question number 69. Can an irregularity in the charge become an incurable illegality?
Yes, an irregularity in the charge as contemplated by section 464 CRPC can be an incurable irregularity within the when failure of justice has happened. When there is failure of justice, if failure of justice has happened, it can be an incurable irregularity. Otherwise, the illegality is curable. And in one case, Supreme Court said, where the accused person charged under sections 448 and 302 read with section 149 had been convicted under section 302 read with section 34, such an irregularity will not vitiate the trial. Boor Singh versus State of Punjab, AR 1974, Supreme Court 1256. Yes, question 70.
Question number 70. How to determine the question of prejudice?
For judging the question of prejudice, the court must act with a broad vision and look to the substance and not to the technicalities. Technicalities is easier to put forward. The main concern of the court should be to see whether the accused had a fair trial, whether he knew what he was being tried for, whether the main facts sought to be established against him were explained to him fairly and clearly, and whether he was given a full and fair chance to defend himself. The principles laid down in Slaney's case, that is William Slaney versus State of Madhya Pradesh, is the leading case on the point. AR 1956, Supreme Court 116, 5 judges, Constitution Bench. Yes, question 71.
Question number 71. What is the extent of the power of the court to alter the charge?
See, there is an unrestricted power in the court to add or alter the charge under section 216 CRPC whenever the court finds that the charge already framed is defective, or when a new charge becomes necessary after the commencement of trial. But such additional alteration has to be made before pronouncement of the judgment. That is what section 216 says. And we have already seen that charge cannot be altered in respect of an accused who has already been discharged. You may refer to 2013 volume 7 SEC 256. Yes, question 72.
Question number 72. Can common intention be formed on the spot at the scene of crime, and how to find it out?
We have already seen that common intention can be formed at the scene of crime on the spot. Only thing is the pre-concert should precede the actual commission of the offense. AR 2001 Supreme Court 3853. Ramji Singh versus State of Bihar. AR 2001 Supreme Court 3853. Only thing is there should be evidence regarding the pre-concert of minds. Yes, question 73.
Question number 73. Charge was framed under section 149 IPC and not under section 34 IPC, but conviction recorded by applying section 34 IPC. Is it correct?
It can be correct and it can be incorrect also. If the charge is framed under 149 and conviction is under 34, for example, if the number of persons had become reduced to less than 5, then 149 charge cannot be, there cannot be a conviction under 149 with the aid of 149. But then for convicting them under section 34 with the aid of section 34, the prosecution of common intention will have to be proved. For that there should be evidence. If there is evidence, then just because there is no charge under section 34, a conviction of under section 302 read with section 34 may not be impermissible. It can be permitted. It can be allowed. Dani Singh versus State of Bihar, AR 2004, Supreme Court 4570. Yes. Next question, 74.
Question number 74. Does the non-framing of a charge under section 149 IPC, which creates a distinct and separate offense, vitiate the conviction?
Again, the position is same. Just because the charge, we have already seen, even the failure to frame a charge may not be very detrimental unless prejudice is able to be shown by the accused. 2009, AR 2009, Supreme Court 2661. Next question.
Question number 75. Is it permissible to prosecute directors who were in charge of and responsible to the company without simultaneously prosecuting the company as well?
Yes, the former view has been overruled. Former view was that even without the junction of the company, the persons in charge of the company could be prosecuted, because the all that was necessary under the old law was that old judicial verdicts was that there should be a finding that the company committed the offense, in which case the persons who are responsible to the company can also be prosecuted without the junction of the company. But that position has been overruled. And in Anita Hada versus Godfather Travels, 2000 AR 2012 Supreme Court 2795 by 3 judges. And thereafter it has been reiterated in 2014, volume 10 SEC 373. Again, in 2015, 9 scale, volume 9 scale 767. The earlier view was 2004 12 SEC 1956. 2004 12 SEC 1956, that it is possible to convict them without the junction of the company. That position is no more good law. Next question, 76.
Question number 76. During preliminary hearing under section 227 CRPC, the accused produces certain unimpeachable documents which, if accepted, are sure to discharge the accused. But the session judge refuses to consider those documents which are of a sterling character. Is it proper?
When documents of a sterling character, which if accepted are the accused, are produced by the accused, but the court refused to look into that. Is it correct? It was the earlier view of the Supreme Court was that court has to look into the documents produced by the accused as well. But that view was overruled by a larger bench of the Supreme Court, 3 judges bench of the Supreme Court, because the wording of section 227 only says, after perusing the final report or the prosecution, the report of the prosecution and the document submitted therewith. And the document submitted therewith means the court can look into the charge sheet as well as the documents produced along with the charge sheet, nothing else. Although section says after hearing the accused, that hearing of the accused will not include the accused producing documents. Therefore, earlier 2 judges bench ruling was overruled by a 3 judge bench ruling in State of Orissa versus Devendra Nath Padi, AR 2005 Supreme Court 359, 3 judges. They said that court is obliged to look into the prosecution records only. Accused cannot do that. But in another case, Supreme Court said that in 482 petition, High Court can do that. Yes. Question 77.
Question 77. Is it permissible for the public prosecutor at the stage of opening the prosecution case under section 226 CRPC to inform the court that since the prosecution witness has been won over by the defense, he will not be examining the witness, that witness?
Yes. 226. See, that is the first stage in a sessions trial. So the prosecutor has to open the case. The prosecutor has to open the case when trial before a court of session is to start, commence. When the accused appears, I am reading 226. When the accused appears before the court in pursuance of a commitment of the case under section 209, the prosecutor shall open his case by describing the charge brought against the accused and stating by what evidence he proposes to prove the guilt of the accused. By what evidence he proposes to prove the guilt of the accused. So at that stage he can tell the court that among the evidence proposed to be adduced by me, one witness has been won over by the defense. Therefore, I will not be examining that witness. He is entitled to say that because of the wording of section 226. Supreme Court has approved that view. AR 2004 Supreme Court 261. AR 2004 Supreme Court 261. Again, similarly, if a witness refuses to give testimony for fear of his life, these are days when such things can happen. The public prosecutor will be justified in refraining from examining such a witness. Shankar versus State of UP, AR 1975 Supreme Court 757. With that, we have completed the questions. I don't claim to have exhausted the entire subject of framing charge. Only thing is, we have some practical questions have been discussed, so that practitioners as well as members of the bench will be benefited by this. My methodology is to apply the law to some concrete fact situations, which we have done. It is for the listeners to give their feedback. Thank you very much. I should especially thank Sunita also for rendering this.
My pleasure, sir. Thank you, sir.
Thank you so much, sir, for making all the efforts and enlightening our young lawyers and students and explaining them one of the most important topics in such a lucid manner. We look forward to more insightful sessions from you. Once again, thank you so much for taking out your valuable time. Thank you so much, Sunita, for moderating the session. Have a great day ahead. Thank you.